is to empower you so that you will be able to get the maximum possible marks in order to pass your exams, if possible with a class pass, honors pass. So that is our intention, and I hope that you have made use of the two webinars that we have had before. On the very first day, I gave you some guidelines as to how to select the best questions for you. What I mean by best is the questions that you have prepared well, and the questions that you feel that you can give good answers. So by giving the best answers in the first few questions, you will be able to impress the examiner. The more you impress, the more marks you will get from the examiner. So therefore, our intention is to help you to try and impress the examiner. And therefore, in my introductory lecture, I gave you the guidelines as to how you should do that. And in the second webinar, we discussed the law of contract, one of the important subjects for the preliminary exam. And what you studied under law of contract will be relevant for industrial law as well. Because when you see the questions, the first question in October 2019 is on job security, termination of employment. So we are going to discuss that question. And the second one is on the classification of workmen and independent contractors. So these are two important topics that you will be expected to study. So let me start with the questions, because the best way to study is to keep the questions in mind. Not that we are question spotting, but these questions will guide us on how we should do that.
Which document you are starting?
The question paper and the other principal points.
Starting with this one, right?
Yeah. And the other one as well. This one as well.
Right.
Question paper. Why is there coming? Cancel that other one. It will not make sense. Cancel. Right.
Right.
Right. Now I have given you the question paper and principal points for the first question and the second question, which you can use as model answers or principal points for the questions, and also two important statutes. One is the termination of employment of workmen, Special Provisions Act of number of 1971 as amended, and the Industrial Disputes Act. You need to use these statutes, important statutes, in order to obtain marks. The first question, if you read with me, the first question is compulsory and it carries 20 marks. So you can earn up to 20 marks if you answer this question well. So therefore, every word of this question is very important. Although it is a two-line question, very short question, a theory question, you will have to address all the important issues in that question. The question is, explain the provisions of the Termination of Employment of Workmen Special Provisions Act in the light of job security of workmen in the private sector in Sri Lanka. So all these words set the conditions subject to which our answer should be written. Now, first one is, now we are required to explain the provisions of the Termination of Employment of Workmen Special Provisions Act in the light of job security. Job security, that is very important for workmen in the private sector, because this act does not apply to the public sector or the semi-government or corporate sector. This applies only to private sector employees, and there are limitations which we have to address in our answer. So I have given you a principal point to which I would like to draw your attention. You can download and use this for your guidance. Now here, I have very briefly dealt with the historical aspect of it, because this is an evolution of job security. So you can't start off with this 1971 Act all of a sudden, unless you relate to the history very briefly. Your answer will not be complete. Now, for example, why do we speak about job security? Well, what is the problem? Then you will understand that under the early law, employers were free to hire and fire workmen. What do we understand by that? Hire means to employ, and fire is to terminate according to their whims and fancies, according to their wish. The only requirement, as you know, employment, the relation between the employer and employee is one of contractual relationship. It's a contractual relationship. There is either a written contract or an implied contract, an express contract or an implied contract. If the employer gives you a letter of appointment, it contains the terms of employment. Terms of employment, how many days leave you get, how much you get as your salary, and things like that. Those are the terms of the contract. But sometimes you won't get a letter of appointment, but there is an implied contract between you and your employer. So under the early law, the theory that applied was the laissez-faire theory, or the freedom of contract. That is, the employer, as the master, had the freedom to employ any workman or to get rid of them whenever they want. The only requirement under the contract of employment was to give notice or to pay an amount of money, salary, in lieu of notice. So the failure to give notice. Now, for example, if the employer terminated the services of an employee, I'm talking about the previous early position, without giving either notice or salary in lieu of notice, it amounts to a breach of contract on the part of the employer. Breach of contract of employment on the part of the employer. So what was the remedy available to the innocent part, the workman? The remedy was, as in any other contract, an action for damages against the employer. Legal action for damages. And as you all know, legal suits or legal action in a court of law is a very cumbersome, expensive, time-consuming procedure, which an employee is unable to afford. Very few employees can afford to institute legal action in the event of a breach of contract on the part of the employer. So therefore, the government as a welfare state concept emerged during 1950s, and therefore in 1957, by an amendment to the Industrial Disputes Act, labor tribunals were established. Labor tribunals. Now, labor tribunals were employed, they were empowered to make orders which appear to them to be just and equitable. That is, the the president of the labor tribunal was not bound even by the contract of employment. And therefore, he was not even bound by the evidence ordinance or even by the contract of employment. Therefore, unlike in a court of law, where the judge is bound by the evidence ordinance and the terms of the contract, the labor tribunal president was free to arrive at a conclusion and award the relief which appears to him to be just and equitable. So you see the influence of equity in labor law as well. Now, for example, this happened in a case which I have given you in my note, Shell Company of Ceylon Limited versus Pathirana, where this was an appeal case heard by the Supreme Court. There the Supreme Court stated that even where the labor tribunal president held that the termination of employment by the employer was lawful and justified, he was entitled to grant relief to the workman. That is because he is not bound by the contract of employment. So under Section 31C, Section 31C1 of the Industrial Disputes Act, what is expected of the president of the labor tribunal is to arrive at a decision which appears to him to be just and equitable. So in this case, in Shell Company versus Pathirana, reported in 64 NLR, the Supreme Court held that although the termination was lawful and justified, the labor tribunal president was correct in granting relief to the employee, the workman. So now you see that the after the establishment of labor tribunals, now the job security is much better than before, because employers, unlike in a court of law, will have to pay compensation sometimes, even where they had terminated the employment lawfully and justifiably. So this is very important when we discuss the job security of private sector employees. Then in 1970, after the new government came into power, there were a lot of salutary labor legislation passed, one of which was Act number 45 of 1971. The title of this act was the Termination of Employment of Workmen within brackets Special Provisions Act number 45 of 1971. Now this act has been further improved by Amendment Law number 4 of 1976 and Act numbers 51 of 1988, 12 of 2003 and 20 of 2008. So now, as the law stands today, now this statute, Termination of Employment of Workmen, Special Provisions Act, provide more job security to private sector employees. But when you examine, the question asks us to examine the provisions of this statute in the light of job security, the light of job security provided to workmen. So now, although this piece of statute, this important statute, provides job security to workmen, we must also
Right, please continue.
Right. Now remember, I told you that the Termination of Employment Act number 45 of 1971 is an effort made by the government to provide more job security. Job security was already there after the establishment of the labor tribunal, but they wanted to enhance the job security by enacting this piece of legislation in 1971. But we must remember, if we examine the provisions of this act carefully, you will understand job security is not the only thing, although it is the main thing that this statute is trying to achieve. At the same time, it is trying to protect small and medium business enterprises also. Because unless if you put the whole burden on the employers will not be able to carry out their business profitably. So therefore, on the one hand, there is a conflict between two competing interests. Now, as you would appreciate, there is a conflict between two competing interests. What are the two competing interests? On the one hand, it is necessary to provide job security. On the other hand, at the same time, business entrepreneurs must be encouraged to engage in business, particularly small and medium scale businessmen will have to be encouraged to do their business with profitably. Therefore, if you examine the various provisions in this act, you will understand how the legislature has achieved this objective. Now, for example, if you take section 3 of the act, it provides that it applies only to employees in the private sector. So definitely it does not apply to the government as an employer, the local government commission or corporations, public corporations, cooperative societies, local government authorities, right? Although they employ employees, they are not governed by the provisions of this statute. And also, so it is very clear now when you examine section 3, it is very clear that it applies only to private sector employees, because they are the people who were considered to be most vulnerable. Because the general belief was that the employees in the government and semi-government sector were more secure. Their job security was much more than those in the private sector. That was the general belief. So therefore, the government wanted to provide job security to these vulnerable sections employed in the private sector. But they have taken into consideration, and I believe that it's a very good balance which the legislature has achieved by these provisions. Now, for example, this act applies only to the private sector employees, not to all the employees, but only to scheduled employment of any workman. The term scheduled employment is defined in section 19. Section 19, which was amended by an amendment law in 1976. But of the scheduled employees employed in the private sector, it does not apply to an employer by whom less than 15 workmen on an average have been employed during the period of 6 months preceding the month in which the employer seeks to terminate the employee. So you find that provision in section 3, subsection 1, paragraph A. Now, what does this mean? This is very important because it is important for us to analyze each of these important sections. So on the one hand, the law wants to provide job security. On the other hand, the legislature is trying to protect the interests of small business undertakings. An employer who employs less than 15 employees is a small business, a small or a medium business. Therefore, to such an employee, this statute does not apply. So please remember, even the Gratuity Act does not apply to such employees. The purpose is to encourage small business entrepreneurs to engage in business with profit. So if this obligation is imposed on them without considering the fact that they are small business entrepreneurs, they will not be able to earn a profit. So therefore, the legislature has taken that into consideration. Now, similarly, termination of workmen who have been employed by an employer for a period of less than 180 days is also not covered by this act. There also, where the employee concerned, whose services had been terminated, had worked for less than 180 days. It shows that his work must have been of a very casual nature. And therefore, such employees are also not covered by this statute. Again, the provision in section 3, subsection 1, paragraph C, has taken into consideration the fact that in every employment there can be an age of retirement. So where the termination has taken place due to the employee reaching the age of retirement, then also the termination does not amount to a termination within the definition of this statute. So termination on account of retirement, on reaching the age of retirement, is also not covered by this statute. There's another salutary feature, another commendable provision of this act is that it does not interfere with the right of the employer to maintain discipline in his place of work. Now, where there is no discipline, there can be business. So therefore, the legislature has taken that also into consideration. And therefore, section 2, subsection 4 provides that termination by reason of a punishment imposed by way of disciplinary action is not covered by this act. So an employee cannot seek relief under this termination of employment act if he had been terminated as by way of punishment due to disciplinary action. Now, for example, if he had committed some act which amounts to a conduct of discipline, then the employer has every right to hold an inquiry or to call for explanation and hold an inquiry and get rid of him. because he is not supposed to keep an employee who is not fit for employment. So therefore, he can sack that person on grounds of disciplinary action. So such termination is also not covered by the Termination of Employment Act. The safety measure provided for such termination is that under Section 2, subsection 5, requires the employer to notify the workman in writing the reason for the termination within 2 working days after the termination, after the date of termination. So where an employer has terminated his employee on the ground of disciplinary action, the employer is bound to give reasons for such termination. So when he has the reasons for his termination, the employee can challenge such termination either in a labor tribunal or in a court of law. So despite, even if the termination was justified, he can go to a labor tribunal. But he can't seek remedies under this provision, Termination of Employment Act. Then, subject to those conditions. Now remember those conditions. One thing, for retirement and disciplinary action, Termination of Employment Act does not apply. So, subject to those conditions, the Termination of Employment Act will apply to non-disciplinary termination. Termination where there is neither retirement on reaching the age of retirement or disciplinary action. There, the employee, if his services had been terminated, can seek remedy unless one of the conditions set out in Section 2, subsection 1 has been fulfilled. Now, what are these 2 conditions? Number 1, for the termination to be lawful, Section 2, subsection 1 of this statute provides that the employer must either obtain prior consent in writing of the workman. If the workman gives his consent, if he had consented to his termination, if the workman had consented to his termination, then he can't complain for relief under this act. Number 2, where the workman has not consented, then if the employer wants to reduce the number of employees, now say for example, this is what is known as retrenchment. If he wants to retrench or to reduce the number of employees, say for various reasons, this can happen due to various reasons. So if the employer wants to reduce the number of employees that he employs, and if the employees whom he is trying to reduce do not give their consent in writing, then there's another way in which he can achieve this objective. But in the other way, he must obtain the approval of the commissioner, labor commissioner, commissioner of labor. So with the approval of the commissioner of labor, he can retrench or reduce the number of employees that he has employed. That's another way of doing it. So if the employees have consented, there's no problem about it. In the absence of consent on the part of the employees, the employer can reduce the number of employees by obtaining the approval of the commissioner, labor commissioner. So remember, subject to these conditions, the Termination of Employment or Workmen Act number 45 of 1971 provides job security to the employees or workmen while protecting the interests of small and medium business undertakings. Then again, now Section 2, Subsection 1 states about consent of the prior consent of the employee. Now this term, prior consent, has been interpreted in a recent judgment of the Supreme Court. Now these judgments are also important for you to obtain high marks, because for your arguments or contentions, you must provide authorities, or you must support your answer with authorities. A recent judgment of the Supreme Court, Lanka Multimolds Private Limited versus Vimala Sen, the Commissioner of Labour and others, reported in 2003, 3 Sri Lanka Law Reports, page 143. The Supreme Court interpreted this term prior consent required by Section 2, Subsection 1, Paragraph A of the Act. So the Supreme Court stated that this prior consent need not necessarily be contained in a single sheet of paper, in a single document. What the court meant was that it could even be inferred from the attendant circumstances in each case. Now, for example, if the employees did not object to their termination expressly, then it may sometimes amount to consent. That is what the Supreme Court has meant. Then again, termination may sometimes amount to even what is known as constructive termination. Anumita seve samapta kirima. Anumita. Constructive. I think you are familiar with this word, constructive. That is, the termination is implied from the attendant circumstances or the conduct of the parties. Now, in this case, the Supreme Court held in Walker and Sons Company Limited versus Guru Singh, reported in 2008, 1 Sri Lanka Law Reports 37, that even a resignation by the employee may in certain circumstances amount to a constructive termination. Now, for example, even if the employee had tendered resignation, a letter of resignation, which the employer had accepted. Now, on the face of it, it appears to be a lawful termination and consent on the part of the employee to terminate his services. But if you examine the circumstances which led the employee to tender his resignation, sometimes the employee would have tendered his resignation because he had no other option but to tender his resignation. Now, say for example, if he had been demoted or if he had been assigned work that does not suit his designation, if things had been made extremely difficult for him to work in the place of work, in such circumstances, the employee might think that there is no point in working with this employer. Therefore, he might decide to resign. So just because he had tendered his resignation, which the employer accepted, there is no termination by resignation. Now, that is what happened in this case, Walker and Sons Company Limited versus Guru Singh. Now, in this case, the appellant workman had been subjected to untold difficulties by the employees. The employer had made his life extremely miserable, and he had made him to tender his resignation. So therefore, the Supreme Court came to the conclusion that despite his resignation, although he had tendered his resignation, in fact, his services had been terminated by the employer. Then Section 2, subsection 4 provides that termination includes these things. What are these things? Now, in Section 2, subsection 4, termination can take various forms. Now, for example, non-employment or the workman in such employment, within bracket scheduled employment, by his employer, whether temporarily or permanently. Now, say for example, if the workers went on strike, and if the strike was a lawful one, after the strike was over, if they report for duty, the employer has no right to deprive them of an opportunity to continue their work. If he does so, under this provision, it may amount to a termination by the employer. And non-employment or the workman in such employment, scheduled employment, in consequence of the closure by his employer of any trade, industry, or business. Now, there the employer also may be innocent, but if he has no work and if he cannot continue with his business profitably, if he has to run the business at a loss, then the employer may be justified in closing his trade, industry, or business. So even such a termination consequent to the closure of his business, trade, industry, so that also amounts to a termination under Section 2, subsection 4, for which the employee can seek relief under this statute. Then Section 5 declares that any termination of employment in contravention of the prohibitions contained in this Act will be illegal, null, and void, and accordingly shall be of no legal effect whatsoever. I hope you understand the meaning of the term void. If it is void, null and void, it means that there is no legal effect whatsoever. It's a nullity. Then Section 6 confers power on the commissioner to order an employer to continue to employ a workman whose employment has been terminated in contravention of the provisions of this Act. Now, so these are the main provisions that you have to be familiar with. Now, in this answer, you have to refer to these provisions of the Act if you want to get good marks. So in your conclusion paragraph, it is not compulsory, but if you have time, it is better to conclude by saying that it is evident from the provisions of this statute that the legislature has struck a balance between job security and the need to allow business enterprises to engage in their business without undue interference. So that is very important for us to remember. So much for question number 1, which carries 20 marks. So you will understand that the legislature has achieved this a great improvement upon the previous legislation. Now, labor tribunals established by the amendment to the Industrial Disputes Act in 1957 was a great achievement which provided a mechanism which was more accessible for employees to seek relief even where the termination was lawful. But this takes the job security a step further by providing these provisions. At the same time, looking after the interests of business undertakings, particularly those of small and medium business undertakings. Then let's have a look at the second question. The second question is a problem question. Remember, I told you the approach to problem question is different from that of a theory question. Now, the second question is a problem question. So, therefore, you must not deal with everything relevant to the topic, but only your answer should be confined to the facts of the problem. And you must address the issues that arise from the problem. So let us read this problem carefully. Colombo Vehicle Clinic Limited, CVC, provides mobile repair services of vehicles in and around Colombo. The company engages 15 persons as mechanics since the commencement of its business in 2013. The company provides T-shirts to the mechanics to wear during their working hours. The company provides motorbikes and tools to the mechanics to provide their service to the customers. The company pays 25,000 rupees as retaining fees to each mechanic and an allowance based on the repairs they undertake during the month. According to the agreement between the parties, the mechanics cannot delegate their work to any other person. The company treats them as independent contractors. The mechanics wish to know whether they are workmen or independent contractors of the company. Advise them. Now you will have to keep the problem, the issues in this problem in mind. What are the issues? Now, the company has employed these people, these mechanics, not on a salary, but on a retaining fee of 25,000 rupees. And they are also paid an allowance, which is calculated on the number of repairs they undertake during the month. So their earnings fluctuate according to the number of undertakings that they have undertaken during the period. And they do not have freedom to employ their own workmen. They can't delegate their work to any other person. But they are provided with motorbikes and tools for their work. And the most important thing is that the company treats them as independent contractors. The company asserts or argues that they are not employees or workmen, but they are independent contractors. So therefore, this problem, the main issue in this problem is to decide whether, due to these reasons, due to these facts, whether these mechanics who work for Colombo Vehicle Clinic Limited, CVC, are in fact workmen or independent contractors. So what is the basic difference between independent contractors and workmen? Now, this is very important, and I have in my note tried to bring out the difference. The main difference is that there are a number of tests that the courts apply in order to solve problems of this nature. An employee or a workman is different from an independent contractor. The basic difference is now, unlike a servant who is under the control of the master or employer, not only in respect of what he is to do, but also the manner in which he is to do the job of work. An independent contractor, for example, has to do the job entrusted to him, but he is not under the control of the master or the employer about the manner in which he is to perform that work. The simplest example that we can think of is that if you employ a driver, for example, if you employ a driver to drive your vehicle, your car, your driver, although he's a skilled person, and although you're not competent in driving, even if you can't control the way in which he drives, he is bound to carry out your orders. You are entitled to control him, not only the work that he does, but also the manner in which he drives the vehicle. But what if you get into a taxi cab? If you get into a taxi cab and tell the cab driver to take you home, the taxi cab driver is not an employee. Why? He is not bound to drive his vehicle according to your instructions. Only thing is, you have indicated the destination and you all have agreed on the fare. That's all. He's an independent contractor. So those tests have been applied, and we must apply those tests. There are a number of tests, and we should apply only the relevant test to this problem. So let us examine the principal points that I have given you. The facts in this problem question must be examined in order to find out whether the mechanics have a contract of service or a contract for service. What is the difference between this? A contract that a workman or an employee has with his employer is a contract of service. Contract of service, seva givisuma. But a contract that an independent contractor has is a contract for service. The taxi cab driver in our example has a contract with you for his services. It's not a contract of service because he is not your employee. So he has agreed to provide you a service, his service, for the fee that you pay. So this is important for us to try and see whether the contract is a contract of service or a contract for service. Now, an independent contractor, as I said earlier, is a person who is told to do a job of work for payment, but he is not subject to the directions and control of the employer as to the manner in which the work should be done. A workman, on the other hand, is an employee employed by an employer to work for him on the term that he, the workman, is to be subject to the contract and direction of the employer in respect of the manner in which his work is to be done. Now here, please remember, what is important is not the ability to control. Now it is relevant for us to discuss this as well. Now, for example, now the mechanics in this problem are skilled persons. They are not unskilled workers. Now, in the case of unskilled workers, it is easier for the employer to have a control over their work. If the workers are unskilled workers, like unskilled laborers, it's easy for the employer to control their work. But in the case of skilled workers, it is difficult to have an actual control over the manner in which they perform their duties. Now, according to the facts of this case, CVC, or the Colombo Vehicle Clinic Limited, employs these people, these mechanics, and thereafter they are sent to their clients to attend to repair work. So the master or the CVC has no actual control over the manner in which they perform the repairs. But if we ask the question whether they have the right to control, the answer will be in the affirmative. So if you get an affirmative answer to that question, it suggests that the relationship is a master-servant relationship, not an independent contractor-employer relationship. Now these people, although they are skilled mechanics, skilled people, the master, CVC, has a right to control. Now remember I told you in the question, the examiner has stated that the company, Colombo Vehicle Clinic Limited, CVC, treats the mechanics as independent contractors. That is their decision, right? Although they exercise sufficient control over these people, they treat them as independent contractors. Now, what is the legal effect? We must examine, we must address this issue. We are supposed to address this issue as well. Whether this decision by CVC to treat the mechanics as independent contractors is valid. Is it conclusive and binding on the parties? Just because they decided to treat them as independent contractors, are they in fact independent contractors or are they workmen? Now this issue has to be addressed in the light of authorities from decided cases. Now there's an English case, an important English case, the name of which is Ready Mix Concrete versus Minister of Pensions, reported in 1968, 2QB 497. There, McKenna J, Justice McKenna, observed that it may be stated that whether the relation between the parties to the contract is that of master and servant, or otherwise is a conclusion of law dependent upon the rights conferred and duties imposed by the contract. Now remember, so according to Justice McKenna in this authority, in this important authority, the decision by either party to treat as independent contractors or workmen is not relevant. It is not conclusive. So whether they are employees, workmen, or independent contractors depend on the conclusion of law dependent upon the rights conferred and duties imposed on the parties. Now, the contract of employment, the contract they have, the CBC Limited and mechanics. Now, what is the nature of duties imposed on the mechanics and what are their rights? That is the important issue. That is the question that we must try and answer. If these are such that the relation is that of master and servant, it is irrelevant that the parties have declared it to be something else. Therefore, the issue whether the mechanics are workmen or independent contractors must be determined having regard to the nature of the rights and duties of the parties. So it is not a straightforward question. So the treatment of the company as independent contractors is not final and conclusive. It is not binding on the parties. Now, as I said before, now in order to answer this question, sometimes, the nature of the work expected of them is also important. Now, sometimes, skilled workers are difficult to control. But our Supreme Court in the Silva versus Trust Company Limited, reported in 55 NLR, stated that what is important is the right to control and not the ability to control. This control test is the main test employed by courts to determine this issue. However, the courts have, in addition, used various other tests, such as integration test, economic reality test, and multiple tests. So they have used a number of tests, but basically it is the control test that is normally used in order to address this issue. Now, we must also refer to the facts in the problem. Now, we are told that the CBC company provides these mechanics with T-shirts, motorbikes, and tools to these mechanics to provide their services to the customers. So work is given to these mechanics by the company, CBC. When the customers come to them, they assign a particular mechanic for that job and he undertakes to attend to that job. The company pays a retaining fee, not a salary. Normally, if the relationship is that of workman and employer, the workman is paid a salary, not a fee. But in this case, the company pays a retaining fee and not a salary. And they are also paid an allowance which is calculated on the basis of the repairs undertaken by them during the month. The agreement between the parties does not permit the mechanics to delegate their work to any other person. What does that mean? The mechanics are not permitted to employ any other workman. So they have to employ the workers provided by the CVC company. Now, do these facts suggest that the mechanics carry on a business of their own? That is the important question to ask. Or are they an integral part of the business of CVC company? Unless they have a separate business, they cannot be considered as independent contractors. Because an independent contractor has a separate business. Now, if you take the example of the taxi cab driver, he has a separate business. We as his customers, hire him for a particular journey. So therefore, he is paid his amount. So he has a separate business. He is not our employee. Likewise, the question arises as to whether these mechanics, although they are skilled workers and although they are paid a fee and not a salary, do they have a separate business to be independent contractors? Now, this question has arisen before the Court of Appeal in Pereira versus Marika Bava Limited in 1989. This case is reported in 1989, 1 Sri Lanka Law Reports, page 347. Now, in this case, what happened was the appellant was the person who appeals. He has appealed against the judgment of the Court of Appeal to the Supreme Court. The appellant was the head cutter of the respondent company. He was provided with a cubicle, but employed his own workmen and used his own tools. Now remember, who is a head cutter? He is the chief tailor of this company. Marika Bava is a tailoring company, famous tailoring company. So they had employed this person, the appellant, for their work. He had been given a separate cubicle, but he employs his own workmen, and he also used his own tools. But in the case in our question, they can't employ their own men, they can't use their own tools. They have to work with the tools provided by the company. And they have to work with the employees provided by the company. But in this case, the appellant has some freedom as to the people whom he employs and also as to the tools that he is using. The company passed on tailoring orders to him, and he was paid a commission from the collection for each month. The Court of Appeal held that the appellant's work was an integral part of the respondent's business. Therefore, he was held to be a workman of the respondent company. Now, if you compare the facts in Pereira versus Marika Bava with those of the question, you will understand that the degree of freedom that the appellant in Pereira versus Marika Bava that was greater than that of the mechanics in our problem. But in spite of that fact, the Court of Appeal came to the conclusion that Pereira, or the appellant, was an integral part of the business of the respondent company, Marika Bava. Why? because the appellant did not have a separate business. Although he was a skilled person, the head cutter is a skilled person, skilled employee. But since he didn't have a separate business, the court of appeal treated him as a workman and not an independent contractor. So it is very important for us to remember that even where work is done by highly skilled persons, like say for example, a private hospital employing a surgeon uh, to perform a surgical operation, then it is true that the hospital, the employer, cannot control the manner in which the surgeon performs his surgery, right? The hospital can't do that. The surgeon is a highly skilled professional, medical professional, who has his discretion in the manner in which he performs his surgical operation. The hospital can't tell him how to do the surgical operation. But is still considered to be an employee or a workman. Why? He does not have a separate business. He is engaged by the hospital. But what if, say, a patient who is treated by a hospital, private hospital, names a particular surgeon for his surgery, and the hospital invites him and provides him with facilities such as operating theaters, in the nursing staff, and also the surgical equipment for the doctor, for the surgeon to perform the surgery. Now, do you see any difference between these two? A doctor who provides his expertise or services to any person who wants his services, not on a full-time basis as an employee, but whenever he gets an invitation, he accepts it and performs the surgical operation. They are the same doctor, right? If he works on a regular basis at a particular hospital, there he will be treated as an employee, a workman. But where he is called by another hospital at the request of a patient, then there he goes as an independent contractor. So the same principle applies here. So therefore, applying the authority of Marikabava versus Pereira versus Marikabava Limited, reported in 1989, 1 SLR, page 347, it appears that the mechanics do not have a separate business of their own. They are an integral part of the Colombo Vehicle Company Limited and are workmen. They have a contract of service with the company, not a contract for service. I hope you understand this difference. This is very important for you to try and understand. So these two questions are on two different topics which are very important. One is on job security. The first one, the various statutory provisions that have been enacted by the legislature for the protection of the job security of a vulnerable section of employees, namely the private sector employees. They are the legislature has been mindful or the fact that job security has to be provided while at the same time providing security to small and medium scale business enterprises. That is an important thing. And in the second question, we distinguished between contracts of employment and contracts for service, contracts of service and contracts for service. Contracts of service are those between employers and employees or workmen. And contracts for service are those between people who give work and those who undertake to perform the work as independent contractors. So in the second example, that is the contracts for service, the person who provides the service has a separate business. And therefore, the person who employs him does not have the control over the manner in which he performs his services. Thank you very much. And I think you must use these two questions. You may use them as model answers, but you must prepare more answers according to this model. You may use them as model answers, but don't try to by heart them. You can't reproduce anything. No. Only thing, the most important thing is to try and understand these principles. Then you will very easily memorize. If you understand, see the rationale behind all these principles. Now, behind all these principles, there's a very important rationale. Now, if you, without discussing the balance that the law is trying to strike between the two competing interests, if you answer the first question only about the job security without dealing with the balance between the two competing interests, then that will affect the number of marks that you are going to get. So what we try to do is to help you achieve more results. In the second question also, it must be a balanced approach. You must discuss the facts. You must avoid irrelevance and vagueness. You won't get any marks for vague statements and irrelevant statements. Now remember, I didn't discuss all the tests because this is a problem question. So it is mainly the control test that I discussed here. Because according to this, the control test and the test, integral test, whether they are. So I didn't say much about the economic test or the multiple test, but they are not very relevant to this. If it is a question on the tests used for distinguishing between these two types of contract, then it would have been relevant. But here, since it is a problem question, I mainly discuss the control test and also the integral test. Thank you very much.
90. Right, good.
Where, how can you get the principal points? This the other document. From here
Yes,
we can.
yes.
All right. Thank you. Am I to start now?
Yes.
Right. I1. Good afternoon. Good morning. Vanakkam. Assalamu alaikum. Dear children, now today I thought of discussing a second subject. Last time, this time I thought I should discuss the law of trusts with you. And I have also given you some material which I feel are important for you. I have given you the principal points for 3 important questions. Question number 1, 2, and 4. I hope that you will find these useful and you will use this as models in order to give complete answers at the exam. Particularly the question 1 is a compulsory question which carries 20 marks, 4 marks more than the other questions. So therefore, this is going to be very important for you. And here the question is a theory question, but it requires you a number of issues. It requires you to address a number of issues. If you know, in the marking scheme, they have allocated marks for each of these points, each of these issues, and therefore you must be careful, you must be clever to identify these issues. And also, believe me, that it is only by reading question paper that you will be able to develop your skill of identifying the issues. Now, question 1 states, it's a statement. It's a statement made by the examiner. So you can either agree or disagree. But whether you agree or disagree, you will have to give your reasons as to why you agree or disagree. If you simply say, I agree with the statement of the examiner, you won't get any marks. Or even if you disagree, you won't get any marks unless you substantiate your argument with reason. You have to give your reasons. So I will read the question and then start discussing with you. All trusts, whether or not they have to satisfy writing requirements, must be sufficiently certain in order to be enforceable. The certainty requirement for trusts are more demanding than for contracts because trusts can affect the rights of parties who did not agree to or participate in its creation. Discuss the reasonable certainty of the matters specified in section 6 of the trust ordinance with reference to the decided cases. Now remember, this question, you will have to break it into a number of component parts. Now, one important part is whether or not they have to satisfy writing requirements. Because if you read section 5 of the trust ordinance, it has given the form in which it has to be, a trust has to be created. When it affects immovable property, it has to be either by last will or by a notarial conveyance, by a document notarially executed. Because as you know, the section 2 of the Prevention of Frauds Ordinance, requires any transaction affecting immovable property to be done by notarial execution. And if the trust property is movable, then writing is not necessary where it is transferred. The ownership of the movable is transferred by delivery. And also, Section 5, subsection 3 says that the provisions in this section, that is Section 5, the provisions relating to writing or delivery in the case of movable property, does not apply where they operate to effectuate the fraud, right? So therefore, that must be remembered. You must have that in mind. And they also speak about certainty in section 6. Now, section 6 requires 4 requirements, and they all have to be stated with sufficient certainty by act or word, right? Word where uh, the agreement is expressed, and where there is no express agreement, it can even be by act, like delivery of movables. So the other important component is the examiner states that they are more demanding than for contracts. Now, the certainty required in the case of trust is more demanding. Why? The examiner has given reasons also. Because trusts can affect the rights of persons, rights of parties who did not agree or who did not agree to or participate in the creation of the trust. So these are the component parts of this question, and we must address all these issues. So I shall discuss with you the principal points that I have jotted down. Now, section 3 of the trust ordinance. Now, we must always try and remember, there are a few sections that we have to try and remember. One of which is section 3. You don't have to reproduce this verbatim, exact words. If you can remember the meaning of this definition and write in your own words, that is fine, that is acceptable. But you can't distort it, and therefore, at least a few words of this definition you must try and remember. Now, section 3 of the trust ordinance defines a trust as trust is an obligation. Trust is an obligation annexed to the ownership of property and arising out of a confidence reposed in and accepted by the owner, or declared and accepted by him for the benefit of another person, or of another person and the owner of such a character that while the ownership is nominally vested in the owner, the right to the beneficial enjoyment of the property is vested or to be vested in such other person or in such other person concurrently with the owner. Now, according to this definition, there are two kinds of interests. One is legal ownership, right? Nominally vested in the owner. The trust property is nominally vested in the owner, and another person has the right to the beneficial enjoyment, but he does not have the legal ownership. So this is a fine combination, good combination between these two kinds of interests. Now, what is the nature of this obligation? Now, we know that even a contract is an obligation. Contractual obligations, right? They arise out of a personal relationship by the exchange of a manifest offer and a manifest acceptance. I have made it very clear in my points, in my principal points. Now, since the examiner has referred to contractual obligations also, he has said that the certainty is even more demanding in the case of trusts than in contracts. Now, even in contracts, unless the rights and obligations of the parties are certain, definite, the judge will not be able to enforce the contract in the event of a breach. In the event of a breach of the contract, when the innocent party institutes legal action, the judge will not be able to enforce their rights unless they are stated with sufficient certainty. But here in the case of trusts, according to the examiner, the certainty requirement is even more demanding in the case of trusts than in contract. Do we agree? Now, this the nature of the obligation. What is the nature of the obligation? In an old case decided in 23 NLR, page 74, Soisa versus Sicilia, Bertram CJ, Chief Justice Bertram, has said that the obligation referred to uh, in the definition of a trust is attached to the trust property, and that is that it is not a personal obligation. So the obligation is attached to the trust property, not to the trustee. So therefore, but in contractual obligations, so, it may or may not be a personal obligation. It all depends on the agreement between the parties. But trust may be created even by one person. Now, please remember, right? A trust may be created even by one person. The same person can be the author of the trust and the trustee, right? So where the author names himself as the trustee, there is no contract as such, because as you know, a person cannot make a contract with himself. For a contract, there must be at least two persons. But trust is different in the sense that even one person alone can create a trust, according to the definition in section 3. So therefore, in such circumstances where the author assumes the role of both author and trustee, the trust can be created without contract, because one person cannot make a contract with himself. But although we don't have to go into details, contractual obligations arise in a different way, right? There's a meeting of minds or agreement between the parties, and the agreement is made by the exchange of a manifest offer and a manifest acceptance. Manifest offer and manifest acceptance. The word manifest means clear, apparent. So the intention must be very clear to make an offer. So they are definite promise. So by the exchange of an offer, a manifest offer and a manifest acceptance, an agreement is formed. A meeting of minds is formed. So whether they have reached the agreement will be determined by the application of an objective test. That is very important. That is, what is important is not what they had in mind, but the meaning that is given to the words they used or the conduct of theirs. And another peculiar character of a trust is that it creates a right to beneficial enjoyment of beneficiaries while the ownership is vested in the owner. And remember, there's another important thing why we can, another reason why we can agree with the statement of the examiner is that, unlike a contractual obligation where the courts are reluctant to make contracts for the parties, the courts do not make contracts for the parties. It is up to the parties to make contracts. But in trusts, in the law of trust, the courts make every effort to give effect to the intention of the author, mainly because a trust may affect the rights of beneficiaries who did not participate in the creation of it. So therefore, the judge, makes every effort to give effect to the trust, the purpose of the trust. Now, for instance, where it becomes unlawful, impossible, or impracticable to carry out the designed designated purpose of a charitable trust, or becomes wasteful to apply all the property to the designated purpose, the trust will not fail, but the court will apply the trust property according to the doctrine of CIPRE. You pronounce it as CIPRE, CYPRES, CIPRE. For this reason, the certainty requirements for trusts are even more demanding than for contracts. Now, for the courts to, give effect to the intention of the creator of the trust, the author of the trust, it must be sufficiently certain. CPA means as near as possible, as near as possible, right? Now, section 5, subsection 1 of the trust ordinance, it speaks about the form. As I said earlier, it can either be by writing or by acts, by word or by acts. Now, section 5, subsection 1 deals with, um, trusts in relation to immovable property, land and buildings, immovable. So there, the section has said, subject to the provisions of section 107, the trust affecting immovable property is not valid unless declared by the last will of the author of the trust or the trustees, or by a non-testamentary instrument in writing signed by the author or the trustee and notarially executed. That is where the trust property forms uh, immovable property. The other trust can be created only by writing, by a notarial conveyance. But section 5, subsection 2 applies to trusts related to movable property. There, the format is more lenient than that under section 5, subsection 1. There, it need not be in writing if the ownership is transferred to the trustee by delivery of such property. Now, say, for example, if a person wants to uh, donate a bus to a particular school, let's say the deaf and blind school, for the use of the inmates of that school, deaf and blind school or a elders home, then there need not be a writing according to section 5, subsection 2. The trust will be valid if the bus is delivered to the trustee. Now, if I create a trust as the author to donate a bus to the deaf and blind school in Takmalana and appoint the matron of that school, the principal of that school, the trustee, all I can do is to hand over the bus, deliver the bus, the movable property to the trustee. That would suffice under section 5, subsection 2. So no writing requirement is necessary in such circumstances. Then again, section 5(3) deals with the situation where this requirement in section 5 and 3, 5 subsection 1 and 2 are relaxed. That is, if the provisions in section 5 subsection 1 and 2, if the rules in sections 5(1) and 5(2) operate so as to effectuate a fraud, the requirement of writing may be relaxed, even in respect of trusts relating to immovable property. That is, the law doesn't help the effectuation of fraud. So in order to prevent such a fraud, the law will relax this requirement of writing. So by doing that, we address the issue related to writing. So whether it is in writing or without writing, a trust may be created. But the next important point is that the requirements set out in section 6 of the trust ordinance must be sufficiently certain. Now section 6 says, subject to the provisions of section 5 and section 107, a trust is created when the author of the trust indicates with reasonable certainty by any words or acts. Now remember, by any words or acts, even acts would suffice. What are the things that have to be indicated with sufficient certainty? Number one, an intention on his part to create thereby a trust. So if there is no definite intention, then the courts will not be able to enforce the trust. Secondly, the purpose of the trust also must be definitely stated with some certainty. Then the beneficiary. The third requirement is beneficiary, and the fourth requirement is the trust property. Now these four requirements have to be stated with sufficient certainty for there to be a valid trust. And in addition, unless the trust is declared by will or the author of the trust is himself to be the trustee, the property, the trust property has to be transferred to the trustee. That also has to be done. So even if all the four requirements are satisfied, if the if the trust property is not transferred to the trustee, there is no valid trust. Then I must bring to your notice that there is a recent amendment made to the trust ordinance. I have attached a copy of this ordinance. I have uploaded a copy of this amendment number 6 of 2018, so that you all can download and use it. It provides further, it is an improvement on the trust ordinance in order to improve the trust, improve the certainty of a trust. There are the beneficiary has been given a new meaning. Unlike the limited meaning under the old ordinance, the new meaning embraces even corporations and also define definitely ascertainable classes of persons for whose benefit the confidence is accepted. That is, now after this amendment, even a trust can even be created for the benefit of a definitely or ascertainable class, definitely ascertainable class of persons, like the members of a particular caste, say for example. So that is acceptable. So the beneficiary has a new definition now. Please use that definition now. Then there's an old case which is still important, Knight versus Knight, an English case. There, the the Court of Chancery has stated the certainties required for a trust were stated as certainty of words, certainty of subject matter, and certainty of objects. And in Sri Lanka, there's a case Fernando versus Joshi, reported in 58 NLR, page 114. At page 115, the court interpreted the requirement of intention in the following words. In construing the terms of a deed, the question is not what the parties may have intended, but what is the meaning of the words they used. So what is important is not the intention, not the actual intention, which is difficult to ascertain, but the meaning of the words that they have used. So that is, the certainty will be understood in that sense. The word person, the definition of beneficiary includes even a corporation. So there is sufficient certainty in a trust if a trust is created for the benefit of a defined or definitely ascertainable class of persons, like the members of a particular caste. It was decided in Anthony Gasper versus the Bishop of Jaffna, 52 NLR, page 230. The subject matter of the trust must also be a transferable property. It cannot be a mere interest. It must be a transferable property. These are all elements of certainty that the question refers to. Now, in addition to the above mentioned developments made by the case law, the Trust Amendment Act number 6 of 2018 provides for a number of new measures to enhance the certainty requirement in trusts. Now, I would like you to read them and understand those. Now, for example, it has inserted new sections 6A and 6B. So I have given a copy of that recent amendment in the hope that you will read it. So you have to improve it. And another new feature that the legislature by this amendment has done is that, it imposes a duty on the registrar general to maintain records of trusts that are made. So that will improve the certainty requirement even more than before. So that way, we can conclude our answer by agreeing with the statement given by the examiner. So I hope you understand that question, the principal point to that question. So let us move on to the second question, principal points. Question number 2. And question number 2 is interesting. It says equity is the means by which a system of law balances out the need to achieve fair results in individual circumstances. Now, this is another statement given by the examiner. So we can either agree with it or disagree with it, but we have to give our reason. Whether we agree with it or disagree, we have to give our reasons as to why we agree or disagree. And we are required to discuss the history and use of equity. As you know, trust law is based on equity. And there's an important difference between equity and law. Now, there are certain areas of law, even in Sri Lanka, which have been influenced by equity. Now, if you take, for example, Section 31C, Section 31C1, the labor tribunal presidents are required to, arrive at a decision which appears to be just and equitable to them. So they are influenced by the principle of equity. And even fundamental rights in fundamental rights applications, the Supreme Court under Article 126(4) is required to give relief which are just and equitable. So therefore, equity plays a very important role in our law also. Now, in this question, we are asked about how the law balances the need to achieve fair results in individual circumstances. Now, let us discuss the principal points for that question. Now, although it is not difficult, it is not easy to find a definition of what equity. Scholars have endeavored to describe its various features. So, in the light of the views or opinions of these scholars, we will have to understand the scope of equity and the function of equity in, as the examiner has stated, in balancing fair results. Now, for example, Professor Penner, who is a well-known, world-renowned scholar on this subject, he has written a book called The Law of Trust. There, he has stated the term equity does not contrast with common law, when the latter is understood to distinguish judge-made law from legislation by Parliament. Now in England, in addition to, even in Sri Lanka, we have a body of case law which are referred to as judge-made law. So on the one hand, we have laws made by Parliament, the legislature, written laws, and laws made by judges, which are judge-made law, common law. What they do is, they when a question comes up before them, they examine the law that exists on that subject and declares that to be the law governing that issue. So it becomes a judge-made law. So therefore, Professor Penner has distinguished between judge-made law and common law. So when you refer to it as judge-made law, it is not difficult for you to understand the meaning of equity. From that perspective, both equity and common law are creations of common law bodies, and principles developed over time, but as judges gave reasons for their decisions in actual cases. So this is important for us to understand that equity is a product of common law, judge-made law, not statute law. As opposed to statute law, equity plays a very important role in balancing fairness. So under the early law, equity was not in. Now we are discussing the historical aspect because the question requires us to discuss the historical aspect as well. So under the early law, equity was not enforced by the common law courts of England. There were a set of common laws, common law courts, and the common law courts did not enforce equity in early times. However, this omission was supplied by the Court of Chancery. Later, the Court of Chancery assumed the duty of enforcing equity. Now, although the primary aim of law is the administration of justice with a view to achieving fairness. Now, despite this main objective of law to achieve fairness, sometimes it appears that the law is unreasonable and harsh. Sometimes, it produces harsh results. Now, for example, now remember if you, under the early law, before the establishment of labor tribunals in Sri Lanka, the only remedy that a person whose services had been terminated was to go to a court of law and sue for damages. There, the judge is bound by the terms of the contract. So if it appears to be fair, if the termination was lawful, the judge can't provide any relief to the employee. But in labor tribunals, the labor tribunal president is not bound by the law. He is not bound by the contract of employment. He can disregard the contract of employment and grant relief to the employee, which appears to him to be just and equitable. So in such circumstances where the law appears to be unreasonable and harsh, in such circumstances, equity plays a pivotal role, important role as a means to avoid such inequitable results. Now, consequent to the efforts of the judges who applied both common law and equity in the same court at the same time, the combination of law and equity began in the 19th century. However, it was stated in MCC Proceeds, Incorporation versus Lehman Brothers International, Europe, 1998, that the Judicature Acts were intended to achieve procedural improvement in the administration of law and equity in all courts, not to transform equitable interests into legal titles or to sweep away altogether rules of common law. Now remember, in trusts, the legal ownership of the trust property is vested in the trustee, and he has all the rights and powers relating to the property. The trustee is expected to exercise his legal rights and powers for the benefit of the beneficiaries according to the terms of the trust. So there are two interests. On the one hand, the trustee has the legal ownership. He is the owner, but he does not have the beneficial rights because the right to the enjoyment of beneficial rights is vested in the beneficiaries. Therefore, the owner, the trustee, has to hold the property, trust property, for the benefit of the trustees, which is very equitable. The general rule is that equity does not determine rights according to law. Instead of that, equity requires individuals concerned to act according to their conscience in such a way as to preserve the equitable interests of others. Now, the law of trusts, which is based on equity, provides the best example to the proposition for this proposition. Dr. L.J. Curre, who has written an important work on trust, states in the law of England, the beneficiary is said to have an equitable estate or an equitable interest to the trust property. Dr. L.J. Curre, at page 187 of his work, argues that the distinction between the legal and equitable estates is foreign to the general law of Sri Lanka. However, his argument, the argument put forward by Dr. L.J. Curre, has not found favor in a number of Sri Lankan cases, such as Narayan and Chetty versus James Finlay, reported in 29 NLR, page 66. So, despite Dr. Curre's, he being a legal academic, his views, the courts have provided remedies applying the law of equity in order to address an issue at hand. Now, it is no secret that the Sri Lankan law of trust is basically based on the English law of trusts. However, as Dr. L.J. Curre at page 188 of his work Trust correctly argues, the content of the law of trust in Ceylon, including the beneficiary's rights, are statutory and be found in the sections of the trust ordinance. Therefore, unlike in England, under the English law of trust, which is entirely based on equity, Sri Lankan law of trusts is to be found in the statutory provisions in the trust ordinance and the case law that interpret the statutory provisions. Now, we have dealt with the major part of the issues in this question. However, the answer to this question will not be complete unless you give some examples on how equity operates to balance the need to just fairness or bring about fair results. Now, if you read chapter 9 of the trust ordinance, which deals with constructive trusts, you find ample examples of how equity operates as a means of balancing fair results in individual circumstances. Now, for instance, if you take section 83 of the trust ordinance, which provides for a constructive trust in the following terms, I think you must try and remember this section, because when you answer a question, you must reproduce these definitions. So section 83 provides in the following terms: where the owner of property transfers or bequeaths it, and it cannot reasonably be inferred consistently with the attendant circumstances that he intended to dispose of the beneficial interest therein, the transferee or legatee must hold such property for the benefit of the owner for his legal representative. Now, what does that mean? Now, an owner of property transfers the ownership in his property to another person, but without consideration, say, for example. So, he has, if he does not obtain consideration or money, the price of the land, although it is called a transfer of property, it actually does not constitute a transfer in the true sense of the word, because the attendant circumstances suggest that he had no intention of transferring the beneficial ownership to the transferee. And therefore, in such circumstances, according to section 83 of the trust ordinance, there is a constructive trust under which the transferee must hold such property for the benefit of the owner or his legal representatives. Now, there is a recent case where this issue was considered by the Supreme Court, and because of the importance of that case, I have uploaded that case so that you all can download it and read it leisurely. Now, in this case, the name of which is Jayasurya Kuranage Ronald Dixon Sumitra Pereira versus Jayasurya Kuranage Padma Janet Jacinta Pereira and others. It is not reported yet. SC Appeal 110/2018. There, what happened was the owner of the property has transferred it to his sister, in order to enable the sister to use the land as security for a loan which he wanted to apply for from a bank. So he transferred the property. He transferred the ownership of the property to his sister without consideration, without taking money. So thereafter, the sister, the transferee, has transferred it to the owner's daughter. A question arose as to whether the transferee of this property had right to transfer the property to that lady, to the previous owner's daughter. Now, in this important case, the Supreme Court recognized that there was a constructive trust under Section 83. So this way, Section 83 of the Trust Ordinance helped the court to avoid an unfair result. If not for Section 83 of the Trust Ordinance, then on the face of it, the transfers both legal ownership as well as beneficial ownership. Whether or not he has received consideration for it, money for it, the transferee gets full ownership, absolute ownership, both legal ownership as well as beneficial ownership, and therefore it will operate as an injustice to the owner whose actual intention was not to give the beneficial ownership but to help his sister who wanted to apply for a loan. So his intention was to enable his sister to obtain for a loan. So therefore, this is a very good example which you can cite to support your argument that equity plays a very important role in balancing and achieving fair results. So that will suffice for the second question. I hope you understand it. I have given the relevant sections as well as the relevant decided cases. Now, I think we have time to discuss another question. I thought that question number 4 in your question paper in October 2019 is interesting. It deals with trusts for unlawful purposes. Now, question number 4, if you read question number 4, explain the provisions in regard to the unlawful trusts with reference to section 4, section 86 and 87 of the trust ordinance and the application of the two maxims in pari delicto potio rest defendantis, conditio defendantis and extirpi causa non oritur actio in this context. Now these two maxims, remember, you would have studied in your law of contract in the first year, in the preliminary year, under illegality, under the consequences of illegality, you would have studied these two maxims. What does in pari delicto potio rest conditio mean? How does it differ from extirpi causa non oritur actio? Now, in pari delicto says that where both parties are equally at fault. What do I mean by both parties? Both the plaintiff and the defendant. Where both parties are equally at fault, the position of the defendant is better than that of the plaintiff. I hope you understand. Where both parties have participated in the wrongful purpose equally, where they are in par, or where they are equally at fault, and the person who complains about it is in a worse position than that of the person who does not complain. The person who does not complain is the defender. So the meaning, the English meaning of this Latin term, Latin maxim, is where both parties are equally at fault, the position of the defendant is better than that of the plaintiff. The other maxim, extirpi causa non oritur actio, is that no illegal contract can be the basis of any legal right. It cannot be the foundation of any claim. In other words, it cannot be the illegal arrangement cannot be enforced at all. Now, the basic difference between these two is that the extirpi causa non oritur actio maxim has no exception whatsoever. And the courts do not enforce illegal contracts for any reason. Whereas in the other maxim, in pari delicto potio rest conditio defendantis, the courts have recognized a number of defenses. Now, basically, for two reasons. One is to prevent an injustice, and the other reason by which courts are encouraged to relax the maxim in pari delicto is to promote public policy. So the courts will relax or recognize exceptions to the in pari delicto principle, either to prevent an injustice or to promote public policy. But the other one, extirpi causa, has no exception whatsoever. So with that in mind, we must examine this question. Now let us look at the principal points I have jotted down. Now section 4, subsection 1 or the trust ordinance provides that the trust may be created for any lawful purpose. Any lawful purpose. Now, note the word created. What does that mean? Now, this section 4, applies only to trusts that are created. In other words, express trusts. And therefore, they do not apply to trusts under Chapter 9 of the Trust Ordinance. Constructive trusts. Now, constructive trusts are not created, no. They are recognized by operation of law. They are not created at all. But these provisions, Section 4, Subsection 1, dealing with these illegal purposes, applies only to created trusts or express trusts. So that section says that a trust may be created for any lawful purpose. Thereafter, it gives some examples when the purpose becomes unlawful. Now, for example, forbidden by law is of such a nature that if permitted, it would defeat the provisions of any law, is fraudulent, involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. So these are the basic grounds that the trust ordinance has laid down. Now, Section 4, as I said earlier, applies only to created trusts, express trusts. And Section 4, Subsection 2 deals with the legal consequences, the effect of illegal contracts. What does it say? Section 4, Subsection 2 says every trust of which the purpose is unlawful is void. And where a trust is created for two purposes, of which one is lawful and the other is unlawful, and the two purposes cannot be separated, the whole trust is void. What does that mean? You know the meaning of the word void. Void means no effect at all. It's of no use. Right? So the trust, if it falls under this definition, then it is of no use. It is of no legal validity. And also, where it is partly lawful and partly unlawful, the doctrine of severance, if it is possible to apply the doctrine of severance, to sever or to separate the lawful part from the unlawful part, the lawful part may be given effect to, and the unlawful part may be void. The illegal purposes stated in Section 4, Subsection 1 are covered by the following three categories of illegality stated by Professor C.G. Veeramanthri. Now, apart from this, the ordinance does not define, although Section 4, Subsection 1 gives a number of illustrations or instances where the purpose becomes illegal. It does not elaborate on those illustrations. So therefore, we may safely refer to Professor C.G. Veeramanthri's work, where he divides illegal objects into three categories, illegal contracts into three broad categories, namely contracts illegal by common law, contracts illegal by statute, and contracts illegal as opposed to public policy or morality. Now, immoral contracts are also illegal as being contrary to public policy. So those are the three broad areas that Professor Veeramanthri has given for illegality. Now, according to section 4, subsection 2, trusts created for illegal purposes are void. And we must remember that it is against public policy to recognize and enforce illegal trusts. Therefore, an illegal trust is null and void. That is to say that the trust has no legal effect from its inception. It is said that the contract, the trust is void ab initio. The Latin term ab initio means from its beginning or from its inception. As a result, the party to such an illegal trust can neither implement it nor recover money or property that has passed under it. Now remember, those two maxims apply when a party to such an illegal trust attempts either to implement the trust or to recover money or property transferred under such illegal trust. These consequences are expressed in two Latin terms, which I stated before. Exterpi causa non oritur actio, no action can be founded on an illegal transaction. That is, no one can enforce an illegal transaction. The court does not assist a person to enforce an illegal transaction. There's a saying, there's an equitable saying that he who comes to court must come with clean hands, with clean hands. So if he comes with unclean hands, then he is not entitled to receive any remedy from the courts. Therefore, under the exterpi causa maxim, there is no exception whatsoever. No person can implement such an illegal trust. But what about the second maxim, in pari delicto potio est conditio? The English meaning of this Latin maxim is where both parties are equally guilty, the defendant's position is superior. So therefore, there are ample exceptions, examples, where the courts are entitled to relax this maxim and provide relief to the claimant, the in pari delicto potio res conditio defendantis, because he does not want to implement it. All what he wants is to recover the property or money passed under the illegal trust. Now, there are good examples under section 86 and 87 where the courts are entitled to relax the maxim in pari delicto. Now, 86 provides as follows. Section 86 says, where the owner of property transfers it to another for an illegal purpose and such purpose is not carried out into execution, or the transferor is not as guilty as the transferee, or the effect of permitting the transferee to retain the property might be to defeat the provisions of any law, the transferee must hold all the property for the benefit of the transferor. Now, if you read this section carefully, you will understand the grounds on which the court is entitled to relax or disregard the maxim in pari delicto. What are the grounds? Number one, where the owner of property transfers it to another for an illegal purpose, and such purpose is not carried out into execution. There you are. Now, say for example, if A and B get together and A transfers his property to um, to for an illegal purpose to B. Thereafter, this illegal purpose has not been carried out. So therefore, no wrongful act has been committed by either party. So in such circumstances, it is not fair to allow B or the transferee to keep the property just because the property was transferred under an illegal trust. So this section 86, one of the grounds on which in pari delicto maxim may be relaxed is where the illegal purpose is not carried out into execution, or the transferor is not as guilty as the transferee. The transferor is not as guilty as the transferee. What does that mean? Now, remember I told you about the meaning, English meaning of the Latin maxim in pari delicto, potio est conditio dependentis. The English meaning is that where both parties are equally at fault, then only the maxim applies. But this section says the transferor is not as guilty as the transferee. Right? So the transferee is more guilty than the transferor. So in such circumstances, the court can relax, the court can disregard the in pari maxim and allow the transferor to recover his property or money paid by him to the transferee. Thirdly, the effect of permitting the transferee to retain the property might be to defeat the provisions of any law. The transferee must hold the property for the benefit of the transferor. That is, if the transferee is permitted to retain the property or money given under the illegal trust by the transferor, it is contrary to public policy because it will amount to an undue enrichment by the transferee at the expense of the transferor. So the law does not allow any person to be unduly enriched at the expense of another person. So for these reasons, the in pari delicto maxim may be relaxed under section 86 of the trust ordinance. So section 86 creates or by the operation of law, a trust is created, a constructive trust, right? Constructive trust is recognized by the courts in favor of the transferor. The transferee in such circumstances, despite the fact that the original purpose of the trust was illegal, if it had not been carried out into execution, or the transferor is not as guilty as the transferee, or if it amounts to undue enrichment, on those grounds, there will be a constructive trust in favor of the transferor. Remember, the purpose is illegal, but for these reasons, section 86 recognizes the constructive trust. So this is important. See how the law has struck a balance. If the law has allowed the transferee to argue on the basis that the since the purpose is illegal, impari delicto prevents him from recovering the property, then it will amount to an injustice. It is unfair by the transferor. So section 86 of the trust ordinance prevents such an unfair result by recognizing a constructive trust, which is very fair. Then section 87(1) is another example where this happens. 87(1) also deals with an unlawful trust. It provides as follows: where a testator bequeaths certain property upon trust, and the purpose of the trust appears on the force of the will to be unlawful, or during the testator's lifetime, the legatee agrees with him to apply the property for an unlawful purpose, the legatee must hold the property for the benefit of the testator's legal representatives. That is by last will. That is why the trust arises in favor of the benefit of the testator's legal representatives. So, if a person, by his last will, bequeaths or gives certain property upon trust to a trustee, to another person, and at the time it may be, at the time of making the contract, it may be lawful, but later, due to subsequent changes in the law, it may become unlawful. Or during the legatee's lifetime, the trustee would have agreed with him to apply the property for an unlawful purpose. Whatever it is, in such circumstances, after the legatee dies, then only the last will becomes operative. So thereafter, the legatee, the person who receives the property, must hold the property for the benefit of the testator's legal representatives. Otherwise, it is unfair. If the legatee is permitted to retain the property just because the trust is unlawful, then it will produce an unfair result. So you will understand that the law has struck a balance between these competing interests. On the one hand, it is important to discourage unlawful trusts. On the other hand, the law does not permit any person to receive undue benefits under this provision. So the law has struck a good balance, an acceptable balance by section 86 and 87 by recognizing constructive trusts in these circumstances. So you will understand that courts have relaxed the maxim in pari delicto potiores conditio defendantis for the following two broad purposes. This has happened in an authoritative South African case called Judge versus Kasim, and the Sri Lankan case Jaffarji versus Subbaya Pillai, 54 in La, page 505. Now, in these two cases, you take these two cases, then you will understand the broad reasons. The reasons may be divided into two broad reasons. What are they? To prevent an injustice or to promote public policy. So for these reasons, the trust ordinance also has endeavored or attempted to strike a balance between these competing interests. So you will find that these constructive trusts have struck a balance between these two competing interests. You may be familiar with these cases. Now, if you take, for example, Jaffarji versus Subbaya Pillai, It was immediately after the World War II, and due to food scarcity, I will, refresh your memory by reminding you of the facts of this important case. It is, in fact, what happened was in that case, in Dafaji versus Subbaya Pillai, there was a price control regulation under which lentils could not be sold over and above a controlled price. And in this case, the plaintiff had agreed with the defendant to buy lentils at a price which was higher than the control price. So because of the violation of this price control regulation, the contract was held to be illegal. But later, the price control regulation was lifted. But remember, at the time the contract was made, it was illegal, and the illegality continued, and it did not cure due to the subsequent change in the law, lifting of the price control regulation. And therefore, the courts allowed him in order to, the courts relaxed this principle, in pari delicto principle, and allowed the plaintiff to recover the money that he paid to the defendant under this illegal contract. So like that, law is always trying to strike an acceptable balance between these competing interests. I hope you understand. I hope that you will find these three questions important, the three questions and the principal points given by me. You will make use of them as model answers. So that's how you must think. Learn to think. That is the key to success. If you think well, you should be able to. There is no reason why you would pass your examination. Thank you very much. Aibon, good afternoon, Vanakkam, Assalamu alaikum. Dear children, today I thought that it is important for us to discuss professional ethics, which is part 2 of your paper on trust accounts, bookkeeping, and professional ethics. Now, this paper consists of 2 parts. Part 1 is on trust accounts and bookkeeping, and part 2 is on professional ethics. Each part has 5 questions, out of which you are required to answer 3 questions. The 100 marks are equally divided between these 2 parts, and you can earn up to 50 marks by answering your professional ethics paper. Now, this is a good opportunity, good combination, because some people who find accounts difficult may score marks by learning to answer the professional ethics questions well. That is the reason why I thought that I should give you principal points or model answers on about 3 questions in the latest question paper, Professional Ethics in October 2019. Now, firstly, this question number 6 is compulsory. Question number 6 is the first question under part 2, professional ethics. It is compulsory, whether you like it or not, you will have to answer it. And it also carries 20 marks. And it has been divided into 3 parts. Part 1 and 2 carry 8 marks each, and the third part carries 4 marks. So altogether, 20 marks have been allocated for question number 1. For the other 4 questions, 16 marks each. So you will have to answer 3 questions from this part, not more or not less. So I have I have attempted to help you with 3 questions so that this will be useful for you when you take up your exams in time to come. Now let us examine the first question, question number 6 in part 2, professional ethics. Now this question is interesting, question number 6. Now part A of question number 6 wants you to explain the term right of representation under section 41 of the Judicature Act number 2 of 1978 as amended. It carries 8 marks. And part B says refusal to admit suspension and removal of attorneys at law, right, within inverted marks, write a full note on the above statement with reference to section 42 of the Judicature Act number 2 of 1978 as amended. Then C, no Attorney General can serve both the state and the private litigant. Explain the above statement with reference to Land Reform Commission versus Grand Central Limited, 1981, 1 Sri Lanka Law Reports, page 250. There are 2 cases, 2 reported cases on the same matter. One is a Court of Appeal case and this one is the Supreme Court case. So I recommend that you read both cases, because the Court of Appeal case, you get more details about this. And although the Supreme Court case is more authoritative, in fact, even the Supreme Court has agreed with the observations of the Court of Appeal. And therefore, I recommend that you read both cases. And I have uploaded both cases for your convenience. So you can download them and study them. Now that you have enough time, read them and try to understand the principles underlying the assertions or the observations of the judges of the Court of Appeal and the Supreme Court. Now let us examine each of these three parts. Part A is explain the term right of representation under Section 41 of the Judicature Act, number 2 of 1978, as amended. Now, I would like you to think about this. Now, what do you think? Now, this section, now this question speaks about a right. But is it in fact a right or a privilege? Now, this question is very important for us to think about. Now, according to Section 41 of the Judicature Act, it is only attorneys at law who are entitled to assist and advise clients and appear, plead, or act in every court or other institutions established for the administration of justice. It further states that every party in a case or who has a claim has the right to be heard in every proceeding, to be represented by an attorney at law. Now remember, now Section 41 speaks about two things. One is that it has given a virtual monopoly to the legal profession. It is only attorneys at law who are entitled to represent other people, clients, in courts and other institutions established for the administration of justice. So a legal monopoly, a virtual monopoly has been conferred on the legal profession. And the other right that this section speaks about is that of the client. That is, every party in a case or who has a claim has the right to be heard in every proceeding, to be represented by an attorney at law. Now, every person has a right to be represented. Now, this question, we must try and understand it clearly, speaks about what does the question speak about? Because we won't get marks unless we are relevant. We answer the question relevant, that is relevant to the question. The question asks about right of representation, not the right to be represented. Right? Explain the term right of representation under Section 41 of the Judicature Act, number 2 of 1978. So remember, I said that there are two rights that this section speaks about. One is right of representation. The other one is right to be represented. So the question is not on the right to be represented. The question is on the right of representation. That is the right of the attorney at law to represent, if it is proper to call it a right. So we must examine whether it is in fact a right. There is no question about the other right, because every person who is a party or who has a claim is entitled to be represented as of right. That is his right. So therefore, it imposes a corresponding duty on the part of the court to allow him to be heard, either in person or, if he prefers to be represented by an attorney at law, the decision is his, not the court's. The court can't say, no, you have no right to be represented. The court can't do that. The court has no right at all. But we must examine about the so-called right of the attorney at law to represent, because the question is on the right to represent. I hope I made myself clear, because this section deals with two rights: the right of the client and the right of the attorney at law. Now, this statutory provision provides for the following two rights I explained earlier. Now, this part of the question on the right of representation of an attorney at law. Now, no other profession has been given this right. It is only attorneys at law, subject to certain exceptions. Now, for example, if you go to a labor tribunal, you will see that even lay persons who are not formally educated in law, who have not been admitted as attorneys at law, are entitled to represent clients. If you go to a labor tribunal, their procedure is very informal. So even a lay person who is not a lawyer is entitled to represent another person. That is in labor tribunals. So subject to those exceptions, it is only a lawyer who can represent others. Now, please remember, every person is entitled. Every person, if he is able to do that, right, he is entitled to be heard by the court or tribunal. So if he wants to conduct his own case, it's up to him. He is free to do that. But if he wants to retain the services of an attorney at law or somebody else, normally he has to retain an attorney at law, not a lay person, subject to the exceptions I told you about labor tribunals. So if he wants to, if he has a court case, say in the District Court of Colombo or the Supreme Court of Colombo, Supreme Court, he has to retain a lawyer. He can't obtain the services of a layperson because the law doesn't permit it. Section 41 doesn't permit it. Now here, what is the nature of this right, the so-called right? Now this was the subject, the scope of the above-mentioned rights, particularly that of an attorney at law, were interpreted by the Court of Appeal in Land Reform Commission versus Grand Central Limited, reported in 1981 to Sri Lanka Law Reports, page 147. Remember, I told you. Now, in this case, the Court of Appeal refused to hear the counsel who appeared on behalf of the Land Reform Commission. Who was the lawyer? He was none other than the then Attorney General, Mr. Siva Pasupati, and his juniors, who were all officers of the Attorney General's department. Now, at that time, they had been granted permission by the government to engage in private practice. They are full-time public servants, Attorney General and all the officers employed in the Attorney General's department. They are full-time officers, public officers. So normally, they are not entitled to appear in court in any capacity other than their official capacity. But since they had been granted permission to engage in private practice, now in this case, a public corporation, Land Reform Commission, retained their services, Mr. Siva Pasupati, the then Attorney General, and his juniors, who were all officers of the Attorney General's department, in their private capacity as private lawyers. So when they appeared before the Court of Appeal, the Court of Appeal refused to hear them. The Court of Appeal said, we are not prepared to hear you unless you appear in your official capacity as the Attorney General and officers of the Attorney General's department. Then he argued that he has a right under Section 41 of the Judicate Act, which is the subject of this question, this part of the question. And this was the subject of this case. So he was not heard. The Court of Appeal refused to hear him because he appeared in his private capacity, being a full-time public servant, public officer of the Attorney General's Department. The court said, no, we are not prepared to hear you because you appear in your private capacity. No person can serve two masters. As the Attorney General is the chief legal officer and legal advisor of the public, the state, his master is the public. So he is a public servant. So at the same time, he can't have another master. So the Court of Appeal put forward that argument and said a person cannot have two masters at the same time, and therefore you must appear in your official capacity. Then what happened? He appealed to the Supreme Court. He appealed to the Supreme Court against this refusal, this decision for the Court of Appeal to refuse to hear him. He challenged this decision, and after hearing the appeal against the said decision, the Supreme Court unanimously affirmed the decision of the Court of Appeal. And this decision is reported in 1981, One Sri Lanka Law Reports, page 250. It is an interesting decision which you all must read. It is an important decision. Both this Court of Appeal decision as well as the Supreme Court decision is important for you. Now, the words, every attorney at law is entitled, the words, you find these words in section 41 of the Judicate Act, number 2 of 1978. Now, do these words imply a right of attorneys at law to represent their clients? That was the issue before the Court of Appeal as well as the Supreme Court. Now, in the Court of Appeal, Justice Rana Singha stated that the right conferred on attorneys at law by section 41 is in fact not a right. Is in fact not a right in the true sense of the term. Why? What is the main reason for Justice Rana Singha's contention? The main reason for this view is that there is no corresponding duty imposed on the courts and other tribunals to hear the courts, hear the attorney at law. There is no corresponding duty as such. But in the case of the client, there's a corresponding duty. So therefore, it amounts to, in the case of a client, he is entitled to, he has a right to be heard. But in the case of a lawyer, attorney at law, whose right is stated in the same section, section 41, the Judicate Act, the Court of Appeal argued, Justice Rana Singha argued that these words do not confer a right on the attorneys at law. It is only a license or a privilege. It is only a privilege or license. If it is a right, there should be a corresponding duty imposed on the courts. The courts can't then refuse on any grounds whatsoever. But since this is only a license or a privilege, the court has a discretion. The court has a discretion to decide on whom they are going to hear. Now, say, for example, if the lawyer is not properly attired, the court is not bound to hear him. Now, say, for example, we as lawyers have a dress code. an attire. So unless the lawyer is properly attired, unless he wears his black tie and his cloak, the court can say, we don't hear you because you are not properly attired, you are not properly dressed. But in the case of a client, they can't say like that. Whether he comes in a sarong or a pair of trousers, he is entitled to be heard, the client. But the lawyer has to be properly attired, otherwise the courts will say, we won't see you as a lawyer. So to that extent, the argument of Justice Rana Singh is correct because the court has full discretion. The court has inherent power to regulate proceedings in courts. Accordingly, the courts have the discretion to decide who would be permitted to represent before the court. And in this case, Land Reform Commission versus Grand Central Limited, the Court of Appeal refused to hear the Attorney General unless he appeared in his official capacity. So this is a very important case which you should try and understand. Excuse me. So this would suffice for this part A, which carries 8 marks. So if you will answer like that, I hope you will get maximum marks. So it carries 8 marks, that part. So there what we have to stress is the whether, although it is called a right, is it in fact a right? So when you when you substantiate your argument, you will understand that it is in fact not a right. It is only a privilege or a license. So therefore, the court has the discretion or the power to refuse to hear a lawyer whom they do not approve. Then the second part of the question is equally important. This question deals with refusal to admit, suspension, and removal of attorneys at law. Write a full note on the above statement with reference to Section 42 of the Judicature Act, number 2 of 1972, as amended. Now, that is important. Now, unlike the first one deals with the right of the attorney at law and the client to be heard. Section 42 deals with another aspect. Refusal to admit, that is before admitting, suspension and removal of attorney, that takes place after admission. Now, before admission, on completion of your final exam and if you successfully pass your final exam and serve your period of apprenticeship, you are entitled to apply to the Supreme Court under Section 42 of the Supreme Court to be admitted and enrolled as an attorney at law. But there, the Supreme Court, the word used is Supreme Court may admit you. The fact that you have completed all the requirements, your final exam and practical training, apprenticeship, even if you prove all that, you can't seek admission and enrollment as of right. Because the word used is the Supreme Court may admit and enroll. So there the Supreme Court is entitled to refuse to admit you. Right? Why? There are good reasons. If before admission, because by admitting a person as an attorney at law, the Supreme Court gives him a license, and the Supreme Court holds him out as a person who is fit to render his services or advise the general public on matters of law. So therefore, the Supreme Court is careful to see that it admits and enrolls only fit and proper persons. The fitness and propriety is dependent on two important things. The Supreme Court looks for two things. What are the two things? Number one is he should be a person of good repute. Good repute. The second one, he or she should be a person of competent knowledge and ability. Now you will complete that by what we are doing now, by passing your exam and by serving your period of apprenticeship for 6 months and following the training, practical training course. All that will make you a person of competent knowledge and ability. But what about the repute? That is something that we cannot help you. So, if the Supreme Court is of opinion that you lack, of course, the Supreme Court will admit, once the principal of law college issues the certificates, the 3 certificates, as well as the practical training certificate and the apprenticeship certificate, the Supreme Court normally does not inquire into it, because on seeing these certificates, the Supreme Court will be satisfied about your knowledge and competence. But the other one, of course, for that also there's a mechanism. You have to have a character certificate obtained from a senior person, senior attorney at law, and you have to be introduced to the registrar of the Supreme Court. You have to, when you submit your applications and the other documents, you can't go alone. You will have to go with an attorney at law, and you will have to be introduced to the registrar of the Supreme Court. Then only he will entertain your application. So those are the safety measures that the Supreme Court will take in order to ensure that you satisfy those two requirements. So, in spite of all these, the Supreme Court is not bound. Now, please remember, the word used in section 40 is that Supreme Court may. So, at the discretion, Supreme Court has the discretion either to admit and enroll you or to refuse to admit you as an attorney at law. That is before admission. After admission, the Supreme Court has exclusive power to exercise disciplinary control over attorneys at law after admission. So section 42 becomes important in the case of lawyers. So by exercising the powers conferred on the Supreme Court under section 42, the Supreme Court has power to either to refuse to admit and enroll attorneys at law and to suspend their practice or remove them from the role of attorneys at law. In the following words, these powers have been specified in the following words. Now, section 42(1) says the Supreme Court shall have power to refuse to admit and enroll any person applying to be so admitted and enrolled as an attorney at law. That is before admission. Then section 42 subsection 2 says every person admitted and enrolled as an attorney at law who shall be guilty of any deceit, malpractice, crime or offense may be suspended from practice or removed from office by any three judges of the Supreme Court sitting together. So these are the two sections, subsections that will empower the Supreme Court, that will confer disciplinary power on the Supreme Court over attorneys at law. And in addition to these sections, the Supreme Court has power under Article 136, to make rules for the enrollment, for the admission, enrollment, suspension and removal of attorneys at law under Article 136 of the Constitution. So the Supreme Court has made rules which are in force now. I have uploaded a set of rules for your benefit. So you may download it and use it. You will have to try and understand these provisions, a number of rules that are more important than others. I will mention them later. So the Supreme Court has made rules. Please read them and try to understand them. They are equally authoritative and important. Now these rules, the rules that the Supreme Court has made under Section 100, under Article 136 of the Constitution, ensure that attorneys at law are persons of good repute and of competent knowledge and the knowledge and ability at the stage of admission, and will continue to be so throughout their career. So that is the importance of these rules. Not only at the stage of admission, because they may be of good repute and competent knowledge at the time of admission, but if they cease to be so at a subsequent stage, the Supreme Court under these rules can take disciplinary action, either to suspend them or to remove them from the role of attorneys at law altogether. Now, Section 67 of these rules, which you may refer to, requires 6 weeks notice prior to the application to be given to the Registrar of the Council of Legal Education and to the Registrar of the Supreme Court, who should cause the applicant's name and place of abode to be posted up at the registry of the Supreme Court. Furthermore, the notice has to be published in the Gazette and a newspaper. So sufficient notice is given to whom? To the general public, who may come forward and say then if they have reasons. Now please remember, not maliciously. If a malicious complaint is made, action can be taken against that person who made the malicious complaint. If the person gives truthful information, it will be useful for the Supreme Court to maintain discipline among attorneys at law. So, when a person applies, he has to give 6 weeks notice. You would have seen these notices. There he says, I shall 6 weeks hence apply to the Supreme Court to be admitted and enrolled as an attorney at law and all that. So 6 weeks notice is given, and such notice is posted on the Supreme Court notice board for the public to read. And also they are gazetted and published in newspapers. So the purpose of these notices mentioned in Rule 67 is to enable the general public to bring to the notice of the Supreme Court any matter that may affect the fitness of the applicant for the office of attorney at law. These measures enable the Supreme Court to exercise its powers made under Section 42(1) and refuse admission. If, however, any person suppresses any relevant information and gets admission, as in Ray Dematagoda, Don Harry Wilbert, 1989, 2SLR, page 18, the Supreme Court may exercise its powers under Section 42(2) to suspend him from practice or to remove him from the office. Unfortunately, this unfortunate incident happened to a lawyer who had a lucrative practice for more than 20 years. It came to light, after about 20 years after his enrollment, that at the time he applied to the law college, he did not have qualifications to enter law college. I think he did not have a credit pass for English. So he had forged the certificate, and it came to light. A close friend of his, brought him to the notice of the Supreme Court after about 20 years. So this resulted in his name being struck off the roll. Then again, a recent unfortunate incident happened where another lawyer, Nagananda Koditwak, was suspended for 3 under these provisions. I have given the reference of that case, Koditwaku's case. If you read that case, you will understand that he had committed the breach of Rule 60 and 61 of the Supreme Court, Conduct and Etiquette for Attorneys at Law, Rules 1988. So this is a very unfortunate incident. So his name was struck off the roll because he was found guilty of these two rules, 60 and 61. So it is important for you to read and understand these rules. So remember, that would suffice for question 6, part B, to earn 8 marks. Then question 6, part C. What does it say? It says no attorney general can serve both the state and private litigant. Explain the above statement with reference to Land Reform Commission versus Grand Central Limited, 1981, One Sri Lanka Law Reports, page 250. So the examiner has referred us to the Supreme Court decision where Chief Justice Neville Samarakun had made this assertion. It was His Lordship, Chief Justice Neville Samarakun, who made this statement. He said no Attorney General can serve two masters, the state and the private litigant. So thereafter, they lost their permission. Thereafter, they were not permitted to practice as private lawyers because of this. Right. Now let us, that carries 4 marks, but even then, 4 marks is also important for us. Let us see what I have done. So you can take this as a model answer. The Attorney General is the chief legal officer and advisor to the state. In that sense, he is a public officer. He is a public officer. In that capacity, his primary duty is to be wholly detached, wholly independent, and to act impartially. For this reason, the Attorney General cannot serve both the state and the private litigants because he has to be wholly independent. He can't, like other private lawyers, he can't appear for private litigants. Then the government had granted permission. This is where mistake has occurred. The government had granted permission to all officers of the Attorney General's Department to engage in private practice in addition to their official duties. In the Court of Appeal case of the Land Reform Commission versus Grand Central, the Attorney General with some of his officers appeared for the Land Reform Commission in their private capacities. However, the Court of Appeal refused to give them a hearing in that capacity, having regard to the functions, powers, and duties attached to the Office of Attorney General. The Court of Appeal was of the view that he could appear before the court only in his capacity as Attorney General. The conflict of interests, obviously there will be a conflict of interest if it is permitted to appear for private parties also. So the conflict of interest was illustrated by a number of questions which Chief Justice Samarakon posed to the then Attorney General. The conflict of interests that could occur if the Attorney General were allowed to appear for private litigants was the main consideration of the Supreme Court's decision that affirmed the Court of Appeal decision. Now, Chief Justice Nibir Samarakon at page 260 of the Supreme Court decision, which is worth reading. I would like you to read it yourself and understand. This was the question posed by Chief Justice Nibir Samarakon to Mr. Siva Pasupati, the then Attorney General. He asked, what would the Attorney General do if, when appearing for one of the claimants in a partition case, is a hypothetical situation, right? An imaginary question that he is asking. What would the Attorney General do if, when appearing for one of the claimants in a partition case, he discovered that the state had a claim, that the government or the state had a claim to the land claimed by his litigant, his client, his private client. Then what was his answer? It was surprising to hear that answer. His answer was that the Attorney General would immediately cease his appearance for the client, advise the state on the basis of the knowledge so gained by him, and then appear for the state. Then the CJ, the Chief Justice, was surprised to hear that answer. The Supreme Court stated such action would amount to jettisoning of the client's interest contrary to the rules of professional ethics enshrined in Section 125 of the Evidence Ordinance, and unethical and contrary to professional ethics. Now, this Section 125 of the Evidence Ordinance speaks about a very important privilege. It is an absolute privilege. Communications between the client and lawyer are absolutely privileged. The lawyer cannot be compelled to give evidence about the communications he had with the client. It is absolutely privileged. The Attorney General is prohibited from giving evidence against his client on the basis of the information he gathered from the communication he had with his client. So the Honorable Attorney General's answer to His Lordship's question in this case is contrary to all these ethical principles. For the above mentioned reason, as the Supreme Court has stated, no Attorney General can serve both the state and the private litigants. So that is our conclusion. And that would suffice for question number 6 or question number 1. And, now, the second question is question number 7 in your paper. Question number 7 asks you to write a note on fees and disbursements under the Supreme Court, within brackets, conduct and etiquette for attorneys at law rules, 1988. This question is about the fees and disbursements. Now, fees is clear. What is disbursements? That is expenses. In addition to your fees, you are entitled to be reimbursed or to collect your expenses also. For example, you will have to pay the court stamp duty. You will have to, have documents prepared and postage. All those are disbursements. So the law does not expect you to spend, to pocket out from your money. The client should provide it to you. So this question is about this, but there are certain restrictions. So it is equally important for us to know the law as well as the restrictions or the limitations based on this right. This is a right given to the lawyers. If they are not paid, they can even refuse to provide their services. They can even withdraw under these rules their services by informing court. Without informing, you can't fall into trouble. If you are not paid, why should you work? Then you can inform the court that no instructions or that you have not been paid, and therefore you can withdraw from your case. So question 7, the second question in this paper, there we can say that lawyers are members of an honorable profession and they make their living by practicing profession. Dr. A.R.B. Amarsinha, I'm sure that you have read his book on professional ethics. In that book, he says an attorney at law is not engaged in a charitable activity and is not obliged to accept any work unless the client is prepared to meet the expenses of litigation and to pay his fees. Therefore, Rule 5 of the Supreme Court, Conduct and Etiquette for Attorneys at Law Rules, 1988, which is also known as the cab-rank rule, should be understood subject to this qualification. Now, Section 5 is important for you because this, sometimes without mentioning the number, they might ask questions about the cab-rank rule. Why is this rule called cab-rank rule? Rule 5. If you I have given you the rules. If you read rule number 5, you will understand. What does it say? Now I have the rule. I will read it to you. Now, Rule 5, the subheading which precedes this rule, is termed acceptance of instructions. It says an attorney at law may not refuse to act on behalf of a party or person in any matter or proceeding before any court, proceeding before any court, tribunal, or other institution established for the administration of justice, or in any professional matter at his or her professional fee. There you are. So it expressly provides for the professional fee. So if you are not paid your professional fee, you are not bound to appear for a person. So Section 5 or Rule 5 of the Conduct and Etiquette for Attorneys at Law, which is popularly known as the cab-rank rule. Why do we call it the cab-rank rule? Because, in that sense, the attorneys at law are like, cab drivers at a cab stand. Now, if you have been to the airport, you will see there's a cab stand where when passengers want a cab, they are given to the passengers are given to the cab drivers, and they have to take their turn. When a passenger is given to a particular cab driver, he is not entitled to say, I take only long distance passengers, or I take only foreigners, or something like that. They have no right to do that. So they have to take the passenger given to them. That is why this Rule 5, is called the cab-rank rule. But remember, even this cab-rank rule does not impose an obligation on attorneys at law unless he is paid his fees and disbursements. So the cab-rank rule should be understood subject to this qualification. So lawyers do not engage in a charitable work. They make a living. So therefore they are entitled to be paid. Then after accepting any work, Rule 22 of the above mentioned rules, Attorneys at Law, Conduct and Etiquette Rules of 1988, it permits an attorney at law to withdraw from any professional matter on the failure of the client to pay his fees. If the client does not pay his fees or provide for disbursements in respect of such professional matter, his expenses, a lawyer who provides his services under a legal aid scheme or assigned to defend an accused person should not accept extra charges or fees from the client. Now, this is an important thing for you to remember. Now, attorneys at law sometimes, serve as legal aid lawyers under legal aid schemes. There's a legal aid commission, and there's another system of legal aid provided by the Bar Association of Sri Lanka. There, the attorneys at law are paid a nominal fee, and sometimes, the High Court judges assign lawyers to appear for accused persons who can't afford a lawyer. So they are paid a nominal fee, so they can't claim from the client anything more than the money that the state pays, the government pays. So despite the right of attorneys at law to receive their professional fees and disbursements, they should consider the interests of their clients and the exigencies of the administration of justice as more important. For instance, they cannot jettison the interests of clients abruptly, as Samarkand CJ has stated in Land Reform Commission versus Grand Central Limited. Now remember, in answer to His Lordship's question, The Attorney General said, I will immediately cease to appear for the client and use the information he gathered to appear for the state. So that is not proper for a lawyer to do. A lawyer should not do his work in such a manner as to unnecessarily or improperly increase his client's costs. Consequently, charging of a grossly or clearly excessive fee has been treated as a ground for disciplinary action in Australia. In an Australian case which I have given, it is not proper for an attorney at law who has obtained from his client a sum of money as a loan to appropriate the same unilaterally as against fees due to him for rendering professional services. Now, this was stated in a decided case, Undugodage versus Rasanathan, which I have uploaded, reported in 1989 to SLR 161 at 169 per Arthur J. Similarly, an attorney at law should not accept in lieu of fees a transfer of property as payment for his professional services. So these are the points for question number 2. In order to give a good answer, you'll have to keep these points in mind. Then let us have a look at the third question. You are required to answer only 3 questions. Question number 8 is explain the term relationship with court. The relationship with court under the Supreme Court within brackets, Conduct and Etiquette for Attorneys at Law Rules 1988. So let's have a look at it. I have jotted down some principal points for you for this question. So have a look at it. Relationship with court. Now, Rule 50 to 55 of the Supreme Court, within brackets, Conduct and Etiquette for Attorneys at Law Rules 1988, apply to the relationship attorneys at law have with courts. As we all know, lawyers or attorneys at law are officers of court, although we are not paid by the state. We are not paid by the state, but as soon as we are admitted and enrolled as attorneys at law, we become officers of court, whose primary obligation is towards the courts, not towards the client who pays us. The client who retains us pays our fees. But our primary obligation is not towards him, but towards the court. So we are bound to assist courts in the administration, in the proper administration. Then Rule 50. Remember, I told you rules 50 to 55 deal with this relationship with court. Rule 50 states, Rule 50 imposes a duty on attorneys at law to assist courts in the administration of justice without interfering with the independence of the bar. Right? What does that mean? Now, every member of the bar, every member of the the legal profession, attorneys at law, has to exercise his independence. Unless he is an independent person, he cannot perform his duty properly. So therefore, he must assist the court without any interference with his independence. The rule reflects the norm that attorneys at law are officers of court whose primary obligation is towards courts. Now, Rule 51 elaborates on the elements of the duty imposed by Rule 50. Thus, attorneys at law shall not mislead or deceive or permit his client to mislead or deceive in any way the court or tribunal before which he appears. The question arises whether it would tantamount to misleading court misleading of court if the client accused of criminal offense confesses his guilt to the attorney, and thereafter the attorney undertakes to defend him in court. Now, say for example, if a person who is accused of a murder, say that will you, he retains us as attorney, he retains me as his attorney at law. And later he comes and says, sir, I am the one who killed this deceased person. I stabbed him and killed him. So after that toss, if I continue to appear for him, do I mislead court? Because he has told me that he killed the deceased person. So do I have a right to defend him? These questions arise. Now, Dr. A.R.B. Amarasinghe, in his work on professional ethics, citing Halsbury is an English authority, Halsbury, recommends that the attorney should advise her client to plead guilty. There you are. So if that person tells me that he is the one who killed the deceased person, my duty is to advise him to plead guilty when the question is asked. But please remember, in murder cases, even if he pleads guilty, the proceeding will be conducted. So let's assume minor offense like theft or something like that. So even if he confesses, the lawyer, if the lawyer, attorney at law who defends him, he is entitled to defend him, but he must advise his client to plead guilty. If he admits that he is the one who committed theft or robbery or whatever, he must be advised to plead guilty. And if the client does not do so, and there is enough time for another lawyer to master the case, he should return the brief and ask the client to find another attorney. So that is what he must do. The first thing he must do is to return the brief, if there is time for him to find another lawyer. If he had no time, say for example, if he confessed on the day prior to the trial, so he will not have enough time to retain a lawyer. So in such circumstances, the lawyer can still, despite the fact that he knows that a confession was made, he is entitled to appear for him. So there is no impropriety in showing the court that the prosecution has fallen short of the required standard of proof. So with the knowledge that he confessed, if I decide to appear for him, there is no wrong in telling the court that the prosecution, that the Attorney General's Department has failed to prove the case beyond reasonable doubt. It is lawful for the lawyer to say that, because this type of defense is entirely differing from putting before court an affirmative defense known to be false. Now, say for example, I'll take a very simple example. If the client says, sir, I am the one who committed the robbery. I committed the robbery. So he confesses. And thereafter he says, still, I will pay you, sir. You tell the, right, tell the court that on that particular day, the robbery took place in Colombo. On that particular day, I was in Jaffna. So he wants me to take an affirmative defense. So therefore, if I tell the court with the knowledge that he was in Colombo, that he admitted that he committed theft, if I tell the court that he was in Jaffna, it would amount to misleading court. Because that is an affirmative defense which suggests his innocence. His innocence. But instead of that, if there is any defense, I can plead that, or the burden is on the prosecution to satisfy all the elements of the offense. So if the prosecution has failed to prove the case, prove all the elements of the case offense, then I can take it up as a defense. That is not an affirmative defense. So what is prohibited is an affirmative defense where the lawyer knows that his client has admitted that he had committed the offense. All that an attorney at law could do in such circumstances is to enter a plea of not guilty. A plea of not guilty, and look for the weakness, if any, of the prosecution case. As it is the responsibility of the prosecution to prove the case beyond reasonable doubt. He also can run a technical defense, such as that the indictment is defective, or he has been charged under the wrong law, etc. If that is the case, it should be noted that a plea of not guilty is only a challenge to the prosecution to prove the case. So I am entitled to challenge the prosecution. As an attorney at law, I am entitled to challenge the prosecution to prove the case. There is no impropriety in showing the court that the prosecution has fallen short of the required standard of proof. This type of defense is entirely different from putting before court an affirmative defense known to be false. There's an interesting case reported in 1840, an important English case, which is referred to as the trial of Coosier. The trial of Coosier, which came up before court in 1840. Now, in this case, a very famous barrister by the name Philip, with his junior, defended Coosier. See, Coosier was the accused in this case. So this famous lawyer Philip and his juniors defended Coosier, the accused person, who was charged with the murder of Lord William Russell. He has been accused of the murder of Lord William Russell. So Coosier had been accused of the murder of the deceased person, Lord William Russell. So at the end of the trial, at the end of the first day of the trial, the prosecution witnesses were so shaken up by cross-examination by Phillips, there was a feeling that she would be acquitted. Now this barrister Phillips was a very competent lawyer. The way he conducted his case, the way he cross-examined the witnesses, they were shaken up. by the questions put to them by Barrister Phillips. So they were shaken up, and there was a general feeling that Coursier, the accused person, would be acquitted, not convicted, would be acquitted. C was overjoyed. Sometimes this happens. No? C was overjoyed because he knew that he committed the offense. He was the person who had committed the murder of Lord Russell. So on seeing that he is going to be acquitted, he was overjoyed, and he came to see Barrister Phillips and confessed that it was he who in fact committed the murder of the deceased Lord Russell, and requested the counsel, Barrister Phillips, to continue defending him. But Barrister Phillips was furious at this contention and request. He was very angry. He was so angry that he wanted to give up the brief and cease to appear for Coursier. But his junior counsel, who assisted him, pointed out that the accused person, Coursier, was on trial for his life, and he was entitled to a defense counsel. He had no time to retain the services of another counsel, and therefore what they did was they consulted the Chief Justice, and the Chief Justice advised them, if the prisoner still requests you to defend him, you are bound to do so and use every fair argument from the evidence. They therefore continued to defend C, but he was convicted and sentenced to death. So Coursier was convicted and sentenced to death because of that. Then section 52, remember I told you the relationship with court is governed by rules 52, 55. Then rule 52 states that it shall be the duty of an attorney at law appearing for the prosecution to bring to the notice of the court any matter which, if withheld, may lead to a miscarriage of justice. So he can't repress anything. So he can't suppress anything. If he withholds anything, any important material fact, it will amount to misleading of court. If the withholding of any important material fact leads to miscarriage of justice, it will amount to a breach of duty on the part of the attorney at law under Rule 52. So Rule 53 contains, now for example, under 52, to his knowledge, if there is a defense for the other party, he must inform the court, because he cannot favor his client, although he is paid by the client. His primary duty, his primary obligation is towards the courts in the administration of justice. So even if the information that he possesses goes against his case, his duty is to bring it to the notice of the court. Otherwise, it will amount to a miscarriage of justice and a breach of duty under Rule 52. Then Rule 53 contains prohibitions which prevent attorneys at law from asking questions or making statements that will insult and damage the reputation of the opposite party or a witness or any other person if the attorney at law has reason to believe that such allegation is unfounded or untrue. Now, sometimes, this may happen because we lawyers enjoy absolute privilege, in uh, when we participate in court proceedings. Actually speaking, it is the court proceedings that is privileged, not the person. So therefore, court proceedings, proceedings before courts, is absolutely privileged. So therefore, it is possible for a lawyer to abuse this privilege and ask questions that will be defamatory of other persons. So such questions are not permitted, and if a lawyer misuses the legal proceedings and asks questions of this nature, questions that will insult and damage the reputation of the opposite party or a witness or any other person, if the attorney at law has reason to believe that such allegations are unfounded or untrue. Sometimes, character evidences become relevant. If it is relevant, of course, there is no restriction. You can lead evidence to prove bad character on uh, the part of the person concerned. But in the absence of any such relevance, asking defamatory questions unnecessarily would amount to a breach of the rule under 53, Rule 53. The Rule 54 provides that an attorney at law shall not permit his personal feelings and or interests to influence his conduct before courts. He should not permit his personal feelings or interests to influence his conduct before courts. That is, if there's a conflict of interests, it will amount to a breach of Rule 54. Then Rule 55 provides that an attorney at law shall not discuss the merits of a case with the judge before whom he appears in the absence of the opposite party. Now, this is a very important rule that will preserve, that will ensure transparency and fairness. Transparency and fairness of court proceedings. That is, you are entitled to see the judge in chambers. If you need to see the judge in chambers, you must never go alone. You must always try to go with the other party, with the counsel appearing for the other party. If the attorney at law discusses the merits of a case in the absence of the other party or his lawyer, it will amount to a breach of the duty imposed under this rule, Rule 55. So those are the rules governing the relationship between courts and attorneys at law. So now, within this limited time available to us, we have discussed three important questions, which I hope was useful to you. And you must learn the pattern or the answers that I gave you as model answers or principal. You may call it principal points or even a model answer. So you must cultivate, you must develop the skill, the writing skills, and you must think about and you must think and identify the issues involved in the questions that are given to you. Then only you will be able to develop your skills. Thank you very much. We will decide on the next date for the next webinar uh, in time to come and inform you. And I hope that the session was useful to candidates or students preparing for all three exams, preliminary, intermediate, and final. These will provide a guideline. Well, as an experienced lecturer and examiner, I have served as the chairman of boards of examiners. So I know what they think about the answers, what they expect from you. So therefore, that is the reason why I volunteered to provide my services to you in the hope that in this difficult time, this will be useful to you. So we spend our time and energy in order to help you to achieve good results. We know that we are deprived of access to information or to education due to no fault on our part, but we try to mitigate or minimize the adverse effects of the situation as much as possible. And therefore, if you find it interesting, we will continue with this program with more topics, interesting topics. What I thought was, these discussions and the model answers or principal points that I give you will serve as model answers for you. Thank you very much. Are there any questions?
Yeah.
Only these three questions. Right. Right. Sitara, uh, your question is whether an outsourcing company, if it joins another company, is the outsourcing company an independent contractor? The uh, the answer to this question depends on, as in Pereira versus Marikabawa, the Court of Appeal has correctly stated, it all depends on the rights conferred and duties imposed under the contract. But on the face of it, it appears that since the outsourcing company has an independent, separate business, it has a separate business. So unlike in Pereira versus Marikabawa, where the court said that Pereira, the appellant, although he was a skilled person, skilled head cutter, he did not have a separate business. So therefore, he was an integral part of the company, and therefore he was a workman. But in your question, the outsourcing company, as we know, our experience is that they independently provide their service to the company, the outsourcing company. It's a different company, separate. So they have a separate business. So if that is so, uh, they are independent contractors, not work or employees. So all depends on the facts of the case. Now remember my example of a highly skilled medical professional like a surgeon. Sometimes he plays the role, it all depends. Now when he is retained by a private hospital at the request of a patient, there he goes as an independent contractor. He is not an employee. So the hospital is not responsible for the wrongful conduct of that person, because he is an independent contractor. But if that particular person works in a particular hospital, there, although his work is difficult to control, the employer hospital cannot control the way in which he performs his surgeries, surgical operations. But the hospital is entitled. So what is important is who is entitled to control the work. So if the answer is that the employee is entitled, then the relationship is a contract of employment, master-servant relationship. Right. Right. Now, Mayumi, your question is very interesting. It shows that you have thought about it. Now, affirmative defenses. There are defenses which fall into two categories. Now, affirmative defenses are defenses that suggest that it is not the accused person who committed the offense, but somebody else. Now, say, for example, the defense of alibi, that he was physically not there at the scene of the crime at that particular time at which the offense was committed. In a murder case, say, for example, if that person says that he was far away from that place on that particular day, it amounts to an affirmative defense. So if the lawyer, attorney at law knows it to be untrue, he should never take such an affirmative defense. But there may be other reasons, which mitigate, or even, like self-defense, self-defense is an absolute defense. So you know about it. So they are not affirmative affirmative defenses like alibi. In alibi, of course, what you say is it is not possible for him to commit the offense because he was far away from on that particular day from that particular place. But self-defense or provocation, right? They are not affirmative defenses. I hope that it is clear to you. Right now, you must understand the difference between the privilege enshrined in Section 125 and you know there it is a privilege uh, given to the communications between the lawyer and the client. Section 125 of the evidence ordinance. There, he cannot be compelled to give evidence. If he's compelled, he, I mean, the person who compels him commits a wrongful act. It's a privilege attached to the communication, communications between the client and the attorney at law. But as I made it clear in my discussion, the lawyer, if he knows about anything, even if it goes against him, he must bring it to the notice of the court. It is his duty. He should not suppress information. He must tell the court what his client has told him, but it does not come under the privilege under Section 125 of the Evidence Ordinance. Right. Now, now your question is about something called as public trust. You know, there's a doctrine called public trust doctrine, under which people in power who exert power, who exercise power, are bound to you know exercise their power in good faith. But it does not refer to the trust law. It's not like a charitable trust. It's not like a charitable trust. Or the word used is trust. You know, public trust is a doctrine that is used in constitutional law and administrative law, which requires people in power who exercise power to do it in good faith and in the best interests of the public. Right. Now, I think you have access to the syllabus of this subject. Uh, Anyway, if you want me to give an overview of professional ethics, one thing, there are two guidelines. One is the syllabus content. Syllabus content, I think, which you can have access to it. That is one thing. The other one is you can be guided by the questions, the past papers that they have set. So therefore, it's a very wide subject. It, in fact, the main object of professional ethics is to ensure that after admission, at the time of admission, the question of professional ethics does not arise. It's a question whether he is up to the standard expected of by the Supreme Court under Section 40, Subsection 1 of the Judicature Act, number 2 of 1978. The two requirements are that he should be a person of good repute and a person who has competent knowledge and ability. So thereafter, this question of professional ethics arises after admission. There, the purpose is to see that he maintains the same standards. So the subject overview, if I may say, if you read the rules that I have uploaded, you will get a hazy idea as to what is expected of lawyers, right? The rules, right? Yeah. Now, as I explained, an attorney at law who knows, I think that he may not know, but for some reason, if he comes and if his client confesses to him, if he says that he is the one who committed the offense, uh, he must, as I said, advise his client to plead guilty. And if he does not plead guilty, he is entitled to refuse. He is entitled to refuse to appear for him. So even if he pleads guilty, he can appear and take up any mitigatory defenses like provocation, insanity, or whatever. That is possible. It is possible. Now, affirmative defense suggests the innocence of the accused person. So there may be other defenses as well. Alibi is one for physical impossibility. Now, if that person was not physically present at the scene of the crime, and it was not possible for him to commit the crime of which he is accused, is one. There may be other defenses as well. So now, for example, insanity. Insanity is a total defense which will uh, be an absolute defense. So if a particular person comes and says that he is insane, right? And therefore, to plead that defense, that also may be an affirmative defense if the attorney at law, with the knowledge that he is not insane, takes it up as a defense. So like that, he also, his main duty, please remember, the main primary duty of the attorney at law is towards the court, not the client. Although he is paid by the client, he cannot mislead court. So any defense that will mislead court may amount to, that any defense that suggests the innocence of the accused person may amount to this, right? No, your answer is that if the lawyer finds that the client is lying, what is the next step he can do? That's what happens in, very frequently, very often, clients do not reveal the true story to the lawyer. So that is why, you must put him at ease and tell him that, don't worry, you are free to tell me anything like that. You must try to get the true facts out of him. Otherwise, the lawyer won't be able to defend him. And therefore, as in Kosier's case, he lied, had the lawyer, Barrister Phillips, known about it, he would have refused to advise him. But unfortunately, at a later stage only, it came to light that the client was lying. So therefore, in such circumstances, it is the duty of a clever lawyer to get the truth out of the client. Otherwise, if he's not giving true information under the rules, he is entitled to withdraw from that case if he has already undertaken. If he has not undertaken, this will operate as an exception to the cap rank rule in Rule 5. Rule 5, cap rank rule, you have no discretion but to accept work, but this will operate as an exception where the client is lying. If you have reasonable grounds to believe that he is not telling the truth, you won't be able to defend him. So therefore, you are entitled to withdraw from him or to refuse to help him. And after accepting, it will be a ground for withdrawal from the service. Right. This is you are muted.
Yeah.
You are
Now
muted
okay.
by. Huh?
Okay.
Is it okay now?
Yes.
But still, that okay, right. Now, children, I hope you are listening. You are still with me. And I think we have spent time usefully. So we have made every effort to uh, explain these principles in a way that it is, simply as possible, to make it as simple as possible for you to understand. And I hope whether you answer in English or Sinhala, you would be able to, But unfortunately, although there are requests that we do it in Sinhala, we won't be able to do it because we have to do it by the use of the common language or the link language. Link language, I prefer to use the word link language in the hope that all of you understand. And I hope that this is useful to you. Um, and we'll be continuing these lessons in the hope that you will use them for your success. I hope that you will prepare well and be successful at your examinations. Thank you.